My Lord, conducting counsel, Mr. Panging's out of station, Your Lordship. May I pray that the matter may be listed on 28th of this month?
On?
28th. 28th on Wednesday, next week, Your Lordship.
Heard Miss D. Tamuk, the counsel for the petitioner who submits that the conducting counsel, Mr. D. Panging, is out of station, and on that ground she prays for an adjournment. Considering the submissions made by the counsel, the prayer is allowed. Let this matter be listed again on 28th of August.
My Lord, I beg to mention another item, Your Lordship, item number 25. My Lord, here also Mr. Panging's out of station, Your Lordship. That is why. Can the matter be listed after 2 weeks?
Same order, list after 2 weeks.
Much obliged, Your Lordship.
Your Lordship, I beg to mention item number 9. Lordship, I'm on behalf of Titaba. 9.
What happened? No, 9 is not adjourned.
Noted.
Miss
Navum Sunil.
She has adjourned item number 19. 19.
Your Lordship,
What is your name?
my name is N. Hondik.
N.
Hondik.
Hondi.
I'm on behalf of Titaba.
Learned counsel for the petitioner submitting on behalf of Mr. T. Taba. Prays for an adjournment on the ground of personal difficulty of the conducting counsel.
Lordship.
Considering the submissions, the prayer is allowed. Let this matter be listed after 2
Lordship,
weeks.
there is an interim.
2 weeks. The interim order shall continue. Please.
Much obliged.
Your Lordship, I beg to mention item number 8.
8.
Yes, Your Lordship. The leading counsel, Mr. K. Tagyang, is out of station. So I pray that the matter may be listed.
Heard, Mr.
K. Taja.
What's your name?
K. Taja.
Your name?
Yes, K. Taja. And the counsel is K. Tagyang, leading counsel.
Itaja, learned counsel for the petitioner who submits that the conducting counsel, Mr. K. Tanya, is out of station, and on that ground prays for an adjournment. Considering the submissions made by learned counsel, the prayer is allowed.
Your Lordship, there is an interim order that
Let
may
the interim order shall continue till next day.
oblige, Your Lordship.
Lordship, I beg to mention item number 26.
Yes.
Matter may be taken up after 3 weeks, Lordship.
Why?
The Elverme is out, leading counsel Elverme is out of station.
Who is out of station?
Elverme, leading counsel.
Heard, Mr. What is your name?
S. Yirang.
Heard, Mr. S.
Yirang.
Right, S.
Yirang.
Learned counsel for the petitioner who prays for an adjournment on the ground that Mr. L. Perme is out of station. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
3 weeks, Lordship.
The interim shall continue.
My Lordship, I beg to mention item number 5.
What is your prayer?
Leading counsel is out of station.
Who is the
P.
counsel?
Tapao,
Heard, Mr. What is your name?
BC.
Bishibo, learned counsel for the petitioner who prays for an adjournment on the ground that Mr. T. Tapa, learned counsel for the petitioner, are out of station. Considering the submissions, the prayer is allowed. Let this
Listing on
matter-
28 August.
When?
28 August.
28.
Yes.
We have already fixed. Next week. 3rd of September. September.
May I Lordship? I would like to mention item number 30,
Item number
item 30.
30.
Yes, 30.
What is your prayer?
Leading council is out of station.
30
Modi.
is tagged
Supplementary.
with 31.
Yes, 30. Yes, 30 and 31.
Who is the leading counsel?
Chapok Modi
What is your name?
and Chatum.
Mr. N,
Chatum.
learned counsel for the appellant, submits that the conducting counsel, Mr. Chorpok Modi, is out of station, and on that ground he prays for an adjournment. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, my lord.
May I please your lordship? I like to mention item number 10.
10.
Yeah, on behalf of Agabado, is a leading counsel. Matter may be listed after 3 weeks.
What is your name?
N.T. Tacho,
N.
T. Tacho, T-A-C-H-O, Tacho.
Tacho,
Yes.
learned counsel for the petitioner, who submits that the conducting counsel, Mr. or Miss Lipiniri?
Mr.
Mr. Lipiniri is out of station. On that ground, he prays for an adjournment. Considering the submissions, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Much obliged.
Lordship, I beg to mention item number 30 and 31.
You have already mentioned 30,
Yeah.
31.
Already mentioned.
30 and 31.
Yes, Your Lordship, item 30, Your Lordship, the problem here is, Your Lordship, what I try to indicate, Your Lordship,
Mr. Chorpok Modi is out of station.
is they ought to have informed us prior to mentioning the matter, because
Yeah.
we have prepared the matter yesterday, last night, Your Lordship.
Yes, that is also an issue, miss,
They ought to inform us prior
because
to.
there is a notification of the registry. You have to give an adjournment slip.
Yes, Your Lordship. And when we do not come prepared, they start arguing. This is the problem.
But
Anyways,
if
it's-
the appellant counsel does not come prepared,
anyways, Your Lordship, it's just
okay.
obliged.
Item number 1.
BNSS loan application. Already 96 days behind the bar,
90,
6 days.
what is the offense? POCSO, it's a
POCSO.
charge sheeted case.
Your Lordship, here the issue in this case is, the first is regarding the invocation of this section, and second is this matter pertaining to the same FIR has been disposed of by Justice Habum. So as per the notification of this Guwahati High Court, Your Lordship rule, this matter has to be placed before the same judge.
But if the judge is not in the
Your Lordship, it's done through online, Your Lordship.
through online,
Yes, Your Lordship.
whether it says,
No, it's not stating about the online, but basing on this, your notification, Your Lordship, all the matter which has been disposed of by the earlier judge has been placed before the same judge, Your Lordship.
through online also,
Yes, Your Lordship.
okay. Then it has to go. Heard Mr.
Here as well.
A. Rajkar, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor, who submits that another bail application arising out of the same FIR has been disposed of by a coordinate bench of this court, within bracket, Honorable Mr. Justice B. Habum. Hence, he submits that as per notification number 32 issued by this registry, this matter should be placed before the same court, same bench.
Yes, Your Lordship.
In view of submissions made by learned additional public prosecutor, registry to place this matter before appropriate bench.
Obliged.
Yes,
My lord, this application has been filed for seeking an anticipatory interim order, your lordship. My lord, what has happened in this case?
anticipatory bail.
Yes, your lordship.
What is the offense?
My lord, it has been under 103 of the new act, your lordship.
Murder.
Murder, your lordship. But my lord, the case of the applicant is that he was not involved in the matter, your lordship.
We'll call the case diary.
Yes, your lordship. But I'm also praying for an interim order, your lordship. My lord can go through the FIR, your lordship, at page number 17. There's nothing incriminating against the applicant, your lordship.
What is the allegation?
My lord, the
What is your name?
name of the applicant, your lordship.
Yes, appellant. Nason
Nakon
Borang.
Borang, your lordship.
You are not named in the FIR.
No, your lordship, I'm not named in the FIR.
Then why are you apprehending your arrest?
My lord, the rehab center that was wherein the incident has happened, your lordship, it was being run by me, your lordship, and that is why. And in this,
What has happened? Please read the FIR.
This morning, I came to know that my son, Sri Olip Litin Mukherjee, son of such and such, was murdered by rehab center, such and such, which is owned by Sri Nason Borang. They, rehab center, brought the dead body of my.
Ordered by rehab center.
Yes, your lordship. Actually, a fight has happened between the staffs of the rehab center and the inpatients residing in the rehab center, your lordship. And pursuant to that fight, your lordship, the victim has passed away.
Victim was undergoing treatment in that rehab. center.
Yes, your lordship, he was undergoing treatment.
Yes, Mr. Aitan.
Yes, your lordship, they have earlier approached the learned special court or session court, your lordship. Your lordship may kindly find in page number 27, while rejecting the interim protection, initially interim protection was granted to the accused, your lordship.
Interim protection was granted.
Yes, and later on it was vacated, your lordship.
Why? After perusing the case diary.
Yes,
Yes.
your lordship. And it was further
Then-
directed to surrender before the IO, your lordship.
Then case diary would be, perusal would be
My
necessary.
lord, but then I have already given my statement before the IO, your lordship.
And IO has not arrested you.
No, your lordship.
Then where is the apprehension?
There's still an apprehension, your lordship, because
No, you appeared before the IO.
after the interim order was granted, I appeared before the IO and I have given my statement and then
Thereafter,
thereafter
interim order was
was
vacated.
rejected. Yes, your lordship.
Your lordship, now the issue here is, while rejecting the interim protection, your lordship, the learned session court has directed the accused to surrender before
Where
the
is the?
page number
Sorry.
27, your lordship. Third paragraph, your lordship. Accordingly, the interim bail dated so and so passed by Learned CGM Pasigat is in charge of the
No, what was the logic? Why it was rejected?
lordship.
What was the reasoning given?
Your lordship. Base 164 statement of the victim, other victims, other inmates
He
victims.
is the owner of the rehab.
Yes, your lordship. And at the time of commission of the offense, he was present there as per the CCTV footage.
Whether he was involved or not.
Yes, he was present there, your lordship. And on his direction only, everything has happened according
On
to the.
his direction.
Yes, your lordship.
Is there any evidence?
Yes, your lordship. Your lordship will may kindly come to the rejection bail order, your lordship.
Then let us go through the case diary. Case diary may have to be.
My lord.
Now, your lordship, the second line of argument would be, your lordship, while rejecting the anticipatory bail, the learned court below has directed the accused to surrender before the IO. Now, this issue has been, your lordship, discussed by the various high court and even by the honorable Supreme Court while rejecting the anticipatory bail, whether the learned court below can subordinate court below can direct for surrender the accused before the IO. And your lordship, recently, your lordship, by referring to the Supreme Court judgment, your lordship, the Honorable Kerala High Court, which is reported in live law, your lordship, referring to the Supreme Court judgment, has been held that, your lordship, it can be directed, and basing on that, the bail was rejected.
No, but when his statement was recorded,
Yes, your lordship.
then why direction was given to surrender?
Your lordship, because for further investigation, your lordship, is required custodial interrogation, your lordship. Custodial interrogation is required, your lordship.
Whether there was any such prayer.
Your Lordship, it's,
What I understand that during interim protection, he appeared before I.
yes, Your
He
Lordship.
cooperated in the investigation.
Yes, Your Lordship.
And his statement was recorded.
Yes.
Now, whether there was any material in the diary which necessitated the rejection of interim bail.
After considering the 164 statement of the inmate victims, Your Lordship.
Okay, then let us call for the case diary.
Yes, Your Lordship, because one of these aspect is there of this judgment, because Your Lordship, while rejecting direction was been given. So now, Your Lordship, the question would be, Your Lordship,
He has not complied with the diary.
yeah, complain with the direction, and it will be amounting, whether amounting to this constructive custody or not, because the under the direction of the court is there, Your Lordship. And he has been protected by the court. So now, Your Lordship, may kindly come to Your Lordship, para 14, Your Lordship.
Para 40 now?
Yes, Your Lordship. 14 of the judgment, live law, Your Lordship. The judgment, Your Lordship. They have not assailed the bail order, Your Lordship. This is, they have simply pray this court for exercising the power of the bail jurisdiction. Para 14, Your Lordship.
Yes.
May I read? While 14, Your Lordship. Page number 7. On top, page number 7, para 14.
Yes.
Yes. While dismissing an application of anticipatory bail, is it legally permissible for the court to direct the accused to surrender before the investigation officer or the jurisdictional court within a specific period? 15. The aforesaid question was considered by the Supreme Court in Natu Singh versus State of UP, reported in 2021 SCC Online SC 402, and it was held as follows. Even when the court is not inclined to grant anticipatory bail to the accused, there may be circumstances where the High Court is of the opinion that it is necessary to protect the accused person apprehending arrest for some time due to exceptional circumstances until they surrender before the trial court. For example, the applicant may plead protection for some time as he or she is primary caregiver or breadwinner of his or her family member and need to make arrangement for them. In such extraordinary circumstances, when a strict case for grant of anticipatory bail is not made out, and rather the investigation authority has made out a case for custody interrogation, it cannot be stated that the High Court has no power to ensure justice. It need not mentioning, but this court may also exercise this power under Article 142 of Constitution to pass such an order. However, such discretionary power cannot be exercised in untrammeled manner. The court must take into account the statutory scheme under Section 438 CRPC, particularly when provision of Section 438(1) CRPC, and balance the concern of the investigation agency, complainant, and the society at large with the concerned interest of the applicant. Therefore, such an order must necessarily be narrow, tailored to protect the interest of the applicant while taking into consideration the concern of the investigation authority. Such an order must be reason one. 16. In Antru versus State Inspector of Police, reported in 2015 for KAC 61, this court has held that the direction to surrender militates against the concept of anticipatory bail, and that is illegal for the court to direct the accused to surrender before the investigation officer when court dismiss the application for anticipatory bail. This is no justification at all to direct accused to surrender before the magistrate or the investigation officer. The decision in Antru Supra was followed by this court in Ravindran versus State of Kerala, reported in 2018-1 KAC 620. 17. The principles laid down by this court in Antru Supra and followed by this court in Ravindran, as mentioned above, cannot be considered as good law in light of the dictum laid down by the apex court in Natu Singh Supra. In the instant case, the request has been made by the petitioner to permit him to surrender before the investigation officer can be favorably considered. The case against the accused was registered as early as on so that the investigation officer could not yet arrest the petitioner. If the petitioner is permitted to surrender before the investigation officer by granting him a short time, it would only facilitate the investigation. In the aforesaid circumstances, the prayer for granting pre-arrest bail to the petitioner is rejected. The petitioner is directed to surrender before the investigation officer within a period of 7 days from today. On his surrender before the investigation officer within the above period, Your Lordship.
No. No, what is your submission?
My submission to Your Lordship, when the court has directed to surrender before the concerned, Your Lordship, by considering all the material, then the concerned accused has to surrender before the IO, Your Lordship.
Now, under 438, when we are considering the petition, can we go into the question whether the direction was proper or not? Or they should have preferred in.
This is the issue, Your Lordship. First they have to challenge that order, validity of the order, Your Lordship.
But they have approached this court for apprehending that they may be arrested. If he surrenders, he may be arrested. That is your apprehension.
Yes, Your Lordship.
So 438 lies.
Yes, that
So
is there.
we may peruse the case diary to verify whether that order of the session judge. We may differ from that view also.
Yes, that is always there, Your Lordship.
Now, therefore, I was querying that why the interim order was cancelled. What was the logic given by?
For that, Your Lordship, we have to peruse the order of the session court, Your Lordship.
My lord, the honorable learned judge below has taken into account the submissions
He
made
was
by.
seen in the footage.
Yes, Your Lordship.
He was present at the time of incident.
That is the submission made by the PPF court below, Your Lordship.
The IO of the case in the present in person, and he has strongly objected the interim bail of the accused as he has been seen in CCTV footage. This is the submission of the IO, Your Lord, who is conducting the investigation. While the fighting took place and the accused Nason Borang, the parent applicant, is seen in the footage and he was present at the time of incident. Hence, he is misleading the police.
And dictated to beat them.
It is also stated that the statement of the so and so is changing from time to time during interrogation. After watch the CCTV footage, there is also an eyewitness to witness the incident who deposed that so and so was present. This is there. Your
Let
Lordship.
us verify.
Yes, sir.
We are not giving any interim
My
protection.
lord, my
This
lord-
may not be a case of interim protection
Lord,
because
Honorable
there is
Supreme Court-
clear observation.
Yes, Your Lordship, but then Your Lordship, Honorable Supreme Court in a very recent case, Your Lordship, wherein the the applicant was prosecuted under the UAPA Act, Your Lordship. The Honorable Supreme Court has time and again reiterated, Your Lordship, has held that bail is the rule, Your Lordship, and committal to jail is an exception, Your Lordship. On this ground, I am before Your Lordship, and since.
No, that is the rule. Bail is the rule, jail
Yes,
is
Lordship,
an
but then-
exception.
My lord may also take into
But-
consideration that other staffs who were actually involved in the incident, Your
No,
Lordship, they
but
are
there is a
already
clear
in custody, Your
observation against you by the session judge after perusal of the case diary.
Yes, Your Lordship.
If on perusal of the case diary, we find that that observation was unwarranted, then you will get bail.
And Your Lordship, one more issue is there.
Otherwise, not.
They have
May
in-
also take into consideration that the 161 statement of the applicant has been given, Your Lordship, and then there's nothing further that requires the applicant to be in custodial interrogation, Your Lordship. All the statements and there is nothing that the applicant can go on to tamper with the evidence or witnesses, Your Lordship. On all of the evidences and witnesses have been taken into account, Your Lordship.
Your Lordship, second issue would be, they have approached under 482 of the new BNSS, Your Lordship, where there is some substantial changes in the provision, where interim provision has been struck out, Your Lordship, as amended in the new code.
No, but the
But then, Your
offense
Lordship,
is also under new provision.
Yes, Your Lordship, but in that is why, Your Lordship, I am submitting that for that, Your Lordship has to exercise the inherent power because the provision itself doesn't provide the power of interim protection.
Oh, no, even if provision does not provide, court has that power.
Yes, it- inherent.
Though I am not granting the
Yes,
interim bail
yes.
now, but court has that power, though the statute does not provide. Statute does not bar also.
Yes, Your Lordship. It doesn't bar, Your Lordship, absolutely.
Heard Miss D. Tamuk, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor, as well as,
I'm for a victim, Lord.
what's your name?
O Bingep,
O.
Bingep,
Biniam.
Bingep, BINGGEP.
PRMGGEP,
BINGGEP.
Bingham. Learned counsel for the informant. Stop. This application under section 482 of BNSS 2023 has been filed by the petitioner Nason Boran, who is apprehending his arrest in connection with Pasighat Police Station case number 94/2024 under section 103 within bracket 1, comma 3 within bracket 5 of BNS 2023. Stop. After considering the nature of offense involved in this case, this court is of considered opinion that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary fixing. When
30 or 29 or 30, any.
29 or 30?
29, 8 for case.
Yeah,
diary.
that's. If you oblige.
Like, you know.
Item number 3.
Well, challenging the whole proceedings before the special judge. For that, no prosecution.
Yes, what is the case?
Well, the case is that the learned special judge UPI is conducting trial without a valid prosecution sanction against the applicant, who is a public servant. So now well, let's see.
Who are you, Mr. Maga?
I am a
Not
junior.
whom?
I am a junior teacher, my lord.
You are a teacher.
Junior teacher. Then I
Junior.
was yes. Now trained graduate teacher, my lord. No, come cashier.
Teacher,
Teacher.
come cashier.
Come cashier. No, my lord, that scheme was there. So at that relevant point of time, what had happened was some teachers were assigned with additional tasks, additional charges. So
Teacher in a school or
teacher in a school. my lord. So now that JT junior teacher, now this has been renamed as trained graduate teacher, my lord.
has trained
Graduate teacher,
TGT.
TGT now. Let's see, well, kindly see this FIR is at, complaint is at page 23, dated 28/9/2011.
What is the accusation?
The accusation is that I have mismanaged nearly 2 crore rupees,
2 crores.
2 crore rupees. It was filed by one Obuk Panur, Deputy Director School Education, Upper Subansiri, against the SBI official and against me.
No, what is the allegation? How you?
Yeah,
have-
yes, yes. Well, I'm coming to this. What had happened is, my lord, under Sarva Shiksha scheme, that is for the year 2010 and 11. It is the Deputy Director School Education is the DDO and some member secretary of that scheme in the district, and the Deputy Commissioner is the chairperson of that committee in the district. my lord. So now I am a cashier. My duty is only to process the file and take approval from the bank, take approval from the Deputy Director School Education and also the Deputy Commissioner, which both of them are the joint signatory to the checks. my lord. So now the allegation is that I am a cashier, the check book is in my custody, so I have forged the signature.
You have forged.
Forged the signature. That is the allegation against me. That I have forged the signature in connivance with the official. But then the file says without file noting. Because this is always countersigned by the Deputy Director School Education and the Deputy Commissioner. So there is a question of forging does not arise. Now the second contention is After that, this 28/9/2011, the investigating officer of Daporejo Police Station have started the investigation and recorded recorded as many as 13 witnesses under 161 CRPC. And that apart, my lord, now they have seized 112 numbers of check from DDOC office, my lord. That, my lord, will see at paragraph 6 of my application. This is the charge sheet, my lord.
No, main allegation
Yeah.
against you is that you have forged the checks
Yes,
to the tune of 2 crore something
2 crore something, my lord.
by putting whose signatures you have forged of the DC and the DDO.
Well, for clarity, can we come to page 23?
23, yes.
The complaint, my lord.
Yes,
I'm again complaining that Sri so and so, JT come cashier Daporejo for misappropriation and mismanagement of SSA fund 2010-11 to a tune of rupees 2 crore 12 lakhs, 32,908 rupees only. Earlier also, I lodged a complaint against SSA official Sri Maga.
at what stage the trial is pending now?
Now someone has been, is consideration for the charge, right?
You have
Charge
appeared,
has been framed, my lord.
you have appeared,
Yes, it's on mail 39, page 39.
you have appeared.
Yes, the case records are received in file having transmitted to this court by additional district and session judge Basar White's is order dated 29/2017. As presiding officer was one of the defense counsel and this court is notified court for PC Act of State of Arunachal Pradesh issue summons to accuse and notice to the bailers through concern OCPS for next date for their appearance. List the case on so and so. Now, my lord, the
But-
basic question is,
But this is 9/11 only.
yes, it's-
It is of
now next date is 28, my lord,
28 of
this month,
for
for evidence, my lord,
evidence.
for evidence. Now, my lord, the basic question is, now it is a purely a corruption case in discharge of an official duty, my lord.
No, but if you have forged the signatures,
No, no, this is but it is not a force, misuse, misappropriation. The word forgery is not there. Malala come from the last page, last paragraph of page 23. Based on the effects finding report submitted to the undersigned on 25 August 2011, it was clear that many buildings are not constructed, half constructed and constructed building amount were not paid. Some partial payment were also made. It is clearly understood and seems that the cashier SSA in connivance with bank official have mismanaged and misappropriate, huge amount. Instances have come to my notice on 9 September 2011 when an amount of rupees 14,78,000 rupees only was transferred and deposited through transfer slip to ACO account of Charitable Trust Itanagar. The NGO running RBC NRBC project of SSA at Daporejo. The amount of 14,78,000 only was approved by DC. This again he writes that DC approved by the DC. DC and DDSC Daporejo white check number 979247. There is no case of forgery. It's only they have already approved here. The amount was withdrawn by SSA cashier on dated 6/8/2011 and was to be transferred to account of Charitable Trust Itanagar. As per SSA cashier deposit slip enclosed in the complaint, an amount of rupees 14,78,000 only was transferred and deposited in Charitable Trust Itanagar. But when Charitable Trust update their account, no such amount was found in their account. It seems that the amount was not at all deposited in their account. It is proved beyond doubt that the bank officials are also involved in this fraudulent withdrawal. It is clearly stated in check VC payment to particular schools. All schools of Upper Subansiri districts have bank account in SBI Daporeja. The bank official and cashier SSA knew it very well that all schools have account. In spite of that, why the bank officials allow the cashier SSA to withdraw the amount in cash, which is strictly prohibited in SSA flexi program. The amount are to be transferred in individual school BEC account. The bank passbook was updated and it is seen that a sum of rupees 2 crore 78 lakhs 53,086 rupees only was drawn by the cashier. An amount of rupees 66 lakhs 20,000 178,000 only made payment to BSC and contractor. An amount of rupees 2 crore 12 lakhs 32,980 only was not transferred to BEC. Fund diversion in SSA or flexi program is strictly prohibited. In spite of my repeated complaint in writing, no action taken against the erring SSA official against them till today. Now the matter has gone beyond the label. The government money cannot be misused in that manner. I'm herewith enclosing all the relevant documents, Xerox copies of passbook, withdrawal, administrative approval letter, check, register, number so and so, internal inquiry of Deputy Commissioner with slips of personal account of Albert Mara, District Coordinator, so amounting to so and so, only bank transfer slip or, there is no portion of forgery. Approved, but the money was withdrawn in case from the bank.
Which is prohibited.
Correct. So therefore, there is no forgery. And that is, they, in their statement itself, they have clearly made that approval was accorded by the.
Now, what is your case?
Now, my case is, since he is a junior teacher, trained graduate teacher, comes under the definition of section 21 of the Indian Penal Code. Now, therefore, there is a requirement under section 19 of the PC Act and 197 CRPC. Since this case will cover because before it is everything has occurred before commencing of the BNS. So therefore, there is a requirement under law that there cannot be a prosecution against the government employee without there being a previous sanction from the government.
But this plea you can take before the trial court.
That is one apart, Then second thing, since 2005, there is a notification that normal police station cannot take up the investigation of the investigation of any case under Prevention of Corruption Act. My lord will come to this particular Annexure 3, my lord.
Page.
Page 32, my lord. No, where is that manual? No, manual I have given. This manual is there.
No. You have annexed it, page 32.
Yes. No,
Yes,
this is from the manual. I don't think this is bulky. My younger have done it. Now this is 2012, 12th May 2005. The governor of Arunachal Pradesh is pleased to order creation of a special investigation cell under the Vigilance Department of Government of Arunachal Pradesh to investigate all cases against public servants involving offense punishable under the Prevention of Corruption Act 1988 and the relevant provisions of the Indian Penal Code and all other cognate acts and rules in force. The governor of Arunachal Pradesh is further pleased to declare the above special investigation cell with headquarters at Civil Secretariat Complex Itanagar as a police station within the meaning of clauses of section 2 of the Code of Criminal Procedure 1973 to register and investigate all cases against public servant involving offense punishable under Prevention of Corruption Act 1988 and relevant provision of the Indian Penal Code and other covenant acts and rules in force. The governor of Arunachal Pradesh is further pleased to order that the officers of the above special investigation cell of the bank of the sub-inspector and above cell for the purpose of investigation exercises the power of officer in charge of a police station within the meaning of Clause O of Section 2 of Criminal Procedure Code 1973. Consequent upon creation of the Special Investigation Cell under the Vigilance Department of Government of Arunachal Pradesh, the Governor of Arunachal Pradesh is pleased to order that all such cases as mentioned above at various stages of investigation throughout the territory of the Special of Arunachal Pradesh shall stand transferred to the Special Investigation Cell forthwith. Now, my lord will kindly come back to the charge statement. The law is very clear, no notification is there, my lord. The normal police station cannot.
No, there is no bar. Where is the bar? That normal police station, it says that on the date of notification, the cases pending before normal police will get transferred to the special cell.
No, once, my lord, that there is a designated and specialized investigation organization created by the notification in the name of governor by the state government, meaning thereby all these prevention of corruption cases can only be investigated. That is my
There is
understanding.
No such specific contemplate. You are saying that there is an implied bar. But whether that would vitiate the investigation carried by,
Well, still then, my lord, that is, because that is my understanding and my lord will have.
this needs examination.
Correct. I'm not saying so, my lord. That's why what I am making the submission is that.
No, this may be a issue which needs examination.
Yeah, please. My lord, in the very initial matter, when the FIR was registered, my lord, there was no allegation of any offense under PC Act. That's why the investigation was done by the regular PS and the charge sheet was filed by the regular PS. It is the special judge who has framed the charge.
Okay.
That is the
Sure.
case.
Charge sheet was filed and
Yeah.
Your lordship will come to charge sheet, which is at page number 30, your lordship.
Cognizance was taken.
Lordship will see at page number 31, the last paragraph. The charge sheet was filed only under the sections of IPC, your lordship. Yes. There is no doubt, your lordship, with regard to prosecution sanction, your lordship, that there has to be a prosecution section for a magistrate to take cognizance, your lordship. Now, if I may take your lordship to page number 33, your lordship, where all the issue has arisen from, your lordship. Page number 33.
yes,
The third paragraph, it starts from hence.
yes.
Hence, apart from taking cognizance of offense under section 409, 420, I-120B IPC, I take cognizance of offense under section 13(1)B and 13(1)D of the Prevention of Corruption Act. Now, this is the issue
Correct.
to be fair with the my submission, your lordship. This is where the issue has crept out, your lordship. During FIR, there was no allegation as to PC Act. During filing of the charge sheet, there was no issue as to PC Act. This was a suo motu cognizance was taken by the learned magistrate, your lordship. This to my fair submission is bad in law, your lordship. However, your lordship will see that if your lordship will then come to, because the submission made was that it is at the stage of evidence, your lordship, if your lordship come to page number 12, your lordship.
No, before that,
Paragraph-
before I come to you,
Yes, sir.
Mr. Tara, on what ground you are seeking quashing? That no previous prosecution sanction
Correct. Therefore,
under PC Act.
correct.
But
But, you know-
the case was not registered under PC Act, neither charge sheet was filed under PC Act. So question of previous sanction,
Now, therefore, my lord, page 33 is very important. which the learned additional PP has relied upon. Hence, apart from taking cognizance of, kindly mark this, my lord, apart from taking cognizance of offence under section 409, 420, 120B IPC, I take cognizance of offence under section 13(1), B 13(1).
Whether charges are framed,
Yes,
where is the charge framing order?
It is there.
page number 38, your lordship.
My lord, before this, my lord, let me make one submission.
Yes, yes.
Once, if you have the power, no, under Prevention of Corruption Act, the judicial magistrate does not have the power to take notice. At the most, my lord, committal, 209. At the most committal, my lord. Now from here, my lord, the second window that I'm arguing is, from here, my lord, my right accrues. Because if you are taking cognizance under Prevention of Corruption Act, you are duty bound to follow section 19 of the PC Act and 197 of the CRPC. Without that, you cannot proceed. Now that, kindly come to page 38 now. Page 38 is the cognizance, charge sheet. The charges have been framed. But in the instant case, my lord, both the staffs had not only withdrawn amount of the checks, but also misappropriate that a huge portion of amount without any proper supporting explanation. The acts done by the accused person found beyond their routine official duties for some pecuniary benefits. The IO also highlighted the judgment given in Prakash Singh Badal in 2007, wherein it was stated that no sanction is required for taking cognizance under section 420 IPC against any of the accused persons. After hearing both the counsels, hearing the IO of the case and perusing the citation placed by both the counsels and also perusing the case record submitted by the police under section 173 CRPC, I am of the considered opinion that there exists sufficient evidence to show that the accused persons have committed the offense under so and so. Now, my lord, 420, I also agree. If that is legal, that legal proposition is correct. If somebody has acted beyond the official capacity to embezzle the public fund, then no prosecution sanction is required. But, my lord, when this section 13(1)B and D of the PC Act comes into application, then you must follow the law. What is prescribed in section 19 PC Act and 197 CRPC, my lord. Therefore, my lord, my two contention is the learned judicial magistrate do not have the power to take cognizance under the Prevention of Corruption Act. Number two, in view of that page 38, once there is the applicability of section 13(1)B and D of the PC Act, it is a must case for the state to obtain the previous sanction. On this particular point, my lord, the coordinate bench has already decided without prosecution sanction or the previous sanction cannot proceed with.
But these two orders are of the year 2014 and 15.
15, yes.
And you are coming to the court under 482 now. You could have challenged those orders
Yes.
by preferring.
No, my lord, sometimes what happens, although law says ignorance of law is not an excuse, but still in the context of many people, they do not know. My lord will see paragraph 8.
Okay, I have understood.
Yeah.
Now,
Today, my lord, I am not praying for directly quashing it at the one go. Let there be an stay of the
no,
process.
therefore I'm hearing whether to
Yes.
grant stay or not.
Yes.
Yes, your lordship.
Quashing is, today quashing is not
No, well,
Not a question.
well, I was under the impression that my lord would be trying to dispose of the matter. That's very fair, my lord. Para 8 and
No,
21.
what is your submission?
Your lordship will.
No, if it is, if you don't have a case, we cannot, we may dispose of, we may dismiss also the
Correct,
petition
correct.
at this stage.
Your lordship has rightly pointed out that in the year 2014 and 2015, when the cognizance was taken, your lordship, it could have been they could have approached this court on the earliest occasion, your lordship. It's more than 10 years now, your lordship. The proceeding has already started. Now the submission made that it is at the stage of evidence. Therefore, I was taking your lordship to page number 12, your lordship.
No, but whether the prosecution sanction was necessary in this case.
Your lordship, as per my understanding, your lordship, the honorable magistrate court could not have taken
Take
cognizance in as per section 19 of the PC Act, your lordship. This is absolutely, to be fair with my submission, this is wrong, lawfully wrong, your lordship.
Okay.
However, your lordship will see that
And whether the special judge, the additional session judge could have framed charges.
no, your lordship, no, your lordship.
So ultimately, those provisions might have to be dropped.
Dropped. That's why,
We-
your
we
lordship,
may, under 420, the proceeding will continue.
will continue.
409.
409, 120B, 420, the proceeding will continue, your lordship. Your lordship your lordship is also well aware that your lordship, only with that regard to PC Act, your lordship, since the entire,
Entire proceeding
Case-
will not be,
yes, not because, your lordship. Also, your lordship will see that the their prayer for stay as
no,
such,
stay I am not granting.
your lordship,
We are issuing notice as prosecution has disclosed its stand that it may not press for the charges under PC Act.
yes. The only difficulty here is, your lordship, that after this notification was, before this case was before the magistrate, your lordship, then subsequently to additional district and sessions judge, your lordship. Now, after coming of this notification, your lordship,
Which notification?
the notification NH, which is at page number 32, your lordship.
That is with regard to investigation only. With regard to
No,
investigation.
not this notification. However, your lordship will see that if your lordship will come to page number 39, your lordship, why the notification, the court of special judge at UPI has been notified as a court of special court for PC Act, your lordship.
So
Now,
the-
therefore, the records from the other court was transmitted to this special court only because there was a section of PC Act.
I think yes. No, but it may continue, suppose assuming that the provisions of PC Act does not
Apply.
apply, is not applicable. Then also the special judge may continue with the trial.
Yes, that can be done.
We're issuing notice.
Yes.
No, my lord, kindly see. This,
No, not at this stage.
my lord,
No
I-
interim.
No, my lord, I am not disputing whatever is falling from my lord. My lord, only I am making a small prayer. Let there be no travesty of the justice. For the reasons, if this section 420 has to be tried, these,
Other-
again, the territorial jurisdiction issue will come. Because there is a regular code, say per se, my lord, if the prosecution sanction is not granted under the PC Act, then these court do not have the power to try the to conduct the trial here. There are legal issues, my lord. It is
No.
not that.
We may pass orders while we have not yet come to a finding that it is not applicable. It is a prima facie observation by prosecution.
Yes.
Suppose ultimately it is found that it is not applicable, then High Court may also pass an order in which court it would be tried.
Yes.
Whether it would, your prayer is that entire case should be quashed. Now that is to be examined. If ultimately it is found that entire case need not to be quashed, then there may be an observation by this court,
Yes.
which is the appropriate court before which trial will.
No,
Continue, yes.
therefore, my lord, this is not an individual's capacity that I have mismanaged. There is no question of forgery. Forging a signature and then taking the money, embezzling the money is one thing. But it is, their complaint itself, prima facie, discloses that in connivance with a bank official, there is an approval from the authority, my lord. Kindly take this into consideration, my lord. My lord, I will have to only request my lord to kindly see this, para 8 and 21, why I am praising this of my judgment. my lord.
Para 8 and 21 of,
The authority which I have committed.
no, those are to be now looked into. This is a
Yes.
final order.
No, that's why, my lord, why the interference of this honorable court is called for at this moment is present. Now, these court, the coordinate bench, my lord may differ, but again, if you go to the larger bench, my lord. Well, kindly come, my lord, kindly allow me to read two paragraphs, para 21 and 25, my lord. So from the discussions made above, 21, my lord, I am reading.
Yes, yes.
It is seen that the investigating agency could not produce any relevant evidence or substantial evidence before the competent authority to obtain prosecution sanction against the present petitioner, and for the want of any substantial evidence or proof, for the competent authority refused to issue any sanction against the present petitioner, but the learned special judge Lakhimpur, without any prosecution sanction against the present petitioner, took cognizance against the present petitioner under section 120B, 420, 468, 471 of Indian Penal Code, read with section 13(1)(c) and D and 13(2) of the Prevention of the Corruption Act 1988 in SIC Vigilance PS case number 04/2007. Thus, the cognizance taken by the learned special judge Lakhimpur under the above mentioned section is void ab initio and is liable to be set aside. 25, my lord. Accordingly, the impugn so and so was passed and set aside. So, the fact of the case, my lord, is that once there is a applicability of Prevention of Corruption Act, then you must obtain the previous sanction. That is what considered condition precedent in section 19 of the PC Act, read with section 197 of the Code of Criminal
In
Procedure.
this case, charge sheet was not filed under
CC Act.
PC Act,
Hmm.
the case which you are citing.
No, this was not filed, but the learned court below, the judicial magistrate, who do not have the power to take cognizance. Therefore, my lord, nothing will happen, my lord, kindly for the short duration, kindly stay the process.
Your Lordship, the entire merit of this case that has been placed before Your Lordship is totally different from what the present
Facts.
case is. The facts are completely different.
At least, my lord, once there is a section 13 of the Prevention of Corruption Act, the prosecuting authority ought to have sought the prosecution sanctions, which they have not sought. Now, there is a procedural vitiations. That my lord will pass any appropriate order, just I'll accept because I am a humble court officer, my lord, my duty is to assist.
Noted. It's heard Mr. T.T. Tara, learned counsel for the petitioner. Also heard Ms. T. Zini, additional public prosecutor,
For the respondent number 1 and 4, Your Lordship.
for respondent number 1 and 4. And Mr.
Oh, pardon, ma'am.
O. Bada.
Yes.
Miss, you are
Special public prosecutor,
special public prosecutor,
SIC vigilance.
2 to 3.
special public prosecutor
2 and 3.
appearing for respondent number 2 and 3. This application under section 528 of BNSS, 2023 has been filed by the petitioner Shri Maga Hakom, praying for quashing of the proceeding, quashing of the criminal proceeding on of PCA case number 1/2001/2000 and what is the case number? It is 27. There is some
2011.
It has been renumbered as, your lordship will find at page number 39, your lordship.
PC case number 1.
PC case number 1, 2017 in DRJ Daporizio, PS case
2000
number 77 stroke
2017.
39.
2017 arising out of DRJ PS case number 77/2011. Learned counsel for the petitioner has submitted that he is mainly challenging the order by which learned judicial magistrate first class Dapurijo on 4/9/2014 took cognizance of offense under section 13 within bracket 1 within bracket small b and 13 within bracket 1 within bracket small d of Prevention of Corruption Act 1988 without there being any prior prosecution sanction under the provisions of Prevention of Corruption Act. He has also submitted that the Court of Learned Additional Session Judge Basar also erred in framing charges on 24/6/2015 under section 13(1) within bracket B, comma within bracket D of Prevention of Corruption Act. Stop. Issue notice to the respondents since the learned additional public prosecutor is appearing for, you are appearing for respondent number? Additional
1 and 4, your lordship.
1 and 4 and learned special public prosecutor is appearing for respondent number 2 and 4. No
2 and
for-
3.
2 and 3. No formal notice need to be issued. No formal notice need to be issued. You have been furnished with the copies of the petition.
Yes, your lordship.
Let the scan copy of the record of PCA case number 1/2017 in Dapurijo in DRJ PS case number 77/2011 be called for from the Court of Learned Special Judge PCA, Prevention of Corruption Act, UPR. When we,
Your lordship, after 3 weeks, your lordship, scan copy of the LCR may also be called for.
let this matter be listed again after 3 weeks.
For
As the orders which are mainly impugned in this criminal petition
Page 34, I think.
are of the year 2014. That is order dated 4/9/2014,
36.
passed by Learned Judicial Magistrate Dapurijo in GR case number 101/2011 has been passed about 10 years ago, as well as the order of framing of charges by the Court of Learned Session Judge, additional session judge is also almost 9 years ago. This court is not inclined to pass any interim order at this stage. Let the matter be listed after 3 weeks.
Yes, Your Lordship, the
It
scan
is-
copy of the.
Now that I have directed,
Oh,
scan copy. Scan copy I have,
deeply.
let this matter be listed.
But my lord, even if we read 468 also of the whole CRPC, but there is no such bar.
Barring,
The bar taking cognizance and then also assailing as well, you know. But at 482, when we are now,
no, that we may examine all question, but after 3 weeks.
just I'm apprising, my lord,
Yes.
that normally in such proceedings, there is no such bar, my lord.
No,
Whether
bar is
to
not there.
assess. Well, my lord was trying to make a
No,
point that
only
why
be-
you have delayed in approaching.
only because
the court.
you have approached delayedly.
Yeah, yeah.
Therefore, I think that interim protection may not be justified. That
Okay.
is the only ground.
I,
You may
I,
ultimately get relief, but that depends on what happens in hearing. So after 3 weeks, let the record come.
yeah, my lord, kindly add one line if my lord, don't mind, my lord. That particularly, once the Prevention of Corruption Act charges is invoked, then the judicial magistrate do not have the power.
No, let me not give any opinion at this stage.
Okay, madam.
Let
Okay,
us,
fine.
let us peruse the record.
Grateful.
Deeply.
Item number 4.
Yes, citation you return it back to Mr. Tara.
4 is same issue, Lordship. Item number 4 is same issue, Lordship. Just the petitioner is changed, Lordship. He is an office assistant, Lordship.
It's arising out of same FIR.
It's
right?
Same issue.
Same order,
Yes.
name of the petitioner
Yes,
is Mr.
Mr. Takehali.
Take Hali. Only change the name.
Yes.
Rest, everything remains same.
Item number 6.
My lord.
Yes, what is this?
My lord, this is petition filed for seeking indulgence of my lord of this honored court to quash the supplementary charge sheet number 05/22 bracket under bracket V in respect of petition number 128, my lord.
128.
128, my lord. They order the petitioner, my lord. My lord, offense involved are, my lord, 420, 468, 471, 34 IPC, my lord. My lord, crux of the cases, my lord, the allegations against the petitioners, my lord, is that, my lord. The petitioners, my lord, while applying for this government job, my lord, under meritorious sports quota reservation, my lord, the petitioners have, my lord, wrongfully obtained this, my lord, Peshimal scan signature of the General Secretary, my lord,
Decimal scan
signature of the General Secretary of the, my lord, Karate Association of India, my lord. That is the, my lord, allegation,
Where, on which document?
my lord,
On which document?
on, my lord, form number 1, my lord.
What is form number
Form
one?
number one is, my lord, a certificate, my lord, that is issued by the, my lord, Karate Association of India, my lord.
What certificate?
My lord, that is my credential certificate, that,
Credentials.
yes,
Then
my lord, that this particular persons have, have, uh, uh, participated in the event, my lord. That is the certificate,
Which
basically.
helps him in getting the job.
Yes, my lord. And there
In
are,
that certificate, you have forged the signature of secretary.
my lord, that is the
Tested
allegation,
Signatures of the secretary
my
of
lord,
the
my lord.
Karate Association.
Yes, my lord.
Okay.
That is the allegations, my lord. And my lord, there is also one form is there, Form B. Form B is issued by the State Arunachal Karate Association, my lord, President, my lord. Form 1 and Form 2, my lord. So, my lord, this instant cases is, my lord, germinated from the FIR, my lord. FIR is, my lord, annexure number 1, my lord. Annexure number 1, page 34, my lord.
Now, let me understand.
My lord.
This FIR was filed alleging some forgery of facsimile signatures.
My lord, no, my lord, that is, my lord, FIR, basically the FIR was lodged by the President Arunachal Taekwondo Association, my lord.
Okay.
That is different discipline, my lord. And my lord, petitioners belong to the Karate Association, my lord. So, my lord,
Okay,
in
what
the
was
FIR,
in the FIR, what was alleged?
in the FIR, my lord, so my, in the FIR, my lord, they still, my lord, may I read the FIR?
Now, what is the gist instead?
34, my lord, page 34.
Yes, instead of reading, or you want to read it?
My lord, FIR is basically, my lord,
What is the gist? What is alleged?
it is alleged that it is informed
That you are using fake
No, no, no.
participant certificates.
That's why, my lord, what I'm trying to, my lord, inspire, my lord, is that, my lord. Basically, my lord, allegations here is, my lord, is against the Taekwondo players, my lord. Not against me.
Taekwondo?
Not Taekwondo players, my lord.
Okay,
Not against me, my lord.
you are karate player.
I'm Karate player, my lord.
Okay.
Yes, my lord. So basically, this issues erupted from this very FIR, my lord. This FIR was lodged by the President Arunachal Karate Association, my lord. And my lord, basing on this, stating that some fake medals certificate has been used and the name of this Taekwondo player, my lord. There is their allegation is that the players who have not participated in the event, they are being obtained, yes, my lord, fake certificate of Taekwondo certificate.
Okay.
Yes, that was the, my lord, allegation, my lord. And my lord, basing on this very FIR, my lord, IO conducted inquiry and submitted charge sheet, my lord. That is charge sheet annexure 2, my lord.
Page number?
Page number 40, my lord. 40, my 40.
The charge sheet against how many accused persons?
Charge sheeted against 19 accused person, my lord.
19.
19, my lord.
Including
Not me, my
petitioners.
lord. Not us, my lord. Only including this Taekwondo players, my lord.
You were not charge sheet.
You're not charged in the first this charge sheet.
Okay.
And again, in this, my lord, after submission of this very charge sheet, IU again continued investigation, and they file another supplementary charge sheet, my lord. That is, my lord, page 65, my lord. Here also, my lord, my name is not indicted, my lord. Here, 6 players of Tenikot discipline, my lord, they have been indicted, my lord.
65.
65, my lord. Annexure.
How many accused?
6 accused, my lord.
In the original, charge sheet,
19 accused.
In first supplementary charge sheet,
6 accused.
6 accused. Of which discipline?
That is from, my lord, Tenikot discipline.
What?
Tenikot, my lord. Tenikot, my lord.
T-E?
TENNIKOIT.
Telecoit. What
Yes,
is this?
what is that? Is
This
like
is a sport.
throwing of, yes, ring.
Okay. So they were also using fake certificates.
Yes, that is the allegation, my lord.
Okay.
And my lord,
Allegation means something has been found, therefore supplementary charge sheet has been laid.
my lord.
Thereafter,
My lord, IO has submitted another supplementary charge sheet, my lord. That is page number 80, my lord. Annexure 4. Wherein, my lord, petitioner has been indicted, my lord. Here, my lord, there are total accused persons were there, my lord.
how many?
13.
13.
13 accused persons were present,
Including the 8
including the
petitioners.
petitioners, my lord. Including the petitioners numbering 8, my lord.
Okay. Now, this charge sheet was also in the continued investigation with in relation to the FIR which was lodged by Taekwondo Association.
Yes, on the basis of that very FIR, this charge sheet was filed, my lord.
And what was alleged?
My lord,
What was found in the charge sheet during investigation that you also used fake certificate?
not my lord, exactly fake certificate, my lord. This, my lord may read one of the charges against accused person. More or less, all charges are similar, my lord.
No,
Yes.
now after this filing of charge sheet,
My lord.
have you appeared before the trial court?
My lord, trial is not yet begun, my lord.
Trial has not yet
Not been
started.
begun. Yes, not yet
Whether
started.
you received summons from the trial court?
Not yet,
At
my
what stage it is pending?
Not yet, my lord.
You
Trial,
have not yet received summons.
not my lord.
Summons have not been issued.
No, my lord.
Okay. Now, what is your ground?
Now, my lord, the allegation against me is that, my lord, ours is, my lord, that we have wrongfully obtained the digital signature of the General Secretary of Karate Association of India, my lord, which that is form number 1, my lord. Form number 1, my lord. So, my lord, of late, my lord, we have come across one petition, my lord.
Specimen signatures you have used.
Yes, that is their allegation, but that is not the case, my lord. We have never used, my lord. Because, my lord, if we go through one of
What
them,
was found?
my lord,
What was found during investigation?
against me, my lord.
Yes,
Yes, that is their allegation, man.
that during investigation, it was found that you were using the specimen signatures of the General Secretary of Karate Association of India.
Yes, my lord.
That was found.
That is their allegation, my lord. That is their allegations against me, my lord.
No, allegation is in the FIR only. But during investigation, something was found on the basis of which
No,
charge
that,
sheet was.
so that is why, my lord. My contention is that, my lord, I am nowhere involved in this audience because in this audience, my lord. Because why, my lord? My lord, if peruse one criminal petition, my lord, everything will be clear, my lord. Because, my lord, meanwhile, what happened? One criminal petition was filed before this one court, my lord.
Criminal petition.
Yes, criminal petition number
By whom?
110/24, my lord. By
Yes.
one of the co-accused, my lord. By one of the co-accused.
Co-accused of the second.
Yes, my
supplement.
lord. One of the co-accused, my lord, that particular co-accused is the staff of the Arunachal Karate Association, my lord. His staff, office staff, my lord. His contention is that, my lord. He is the one, my lord, who used this specific signature, my lord, under capacity of being the staff of the Arunachal Karate Association, my lord. His contention is that, my lord, he has been directed by the General Secretary of the Arunachal Karate Association to use the peshimel and digital signature of the General Secretary of the Karate Association of India, my lord.
Of India.
Yes, my lord. Because, my lord, if peruse the one of the authorization, my lord, everything will be, my lord, will be clear, my lord. The authorization is page number 233, my lord. This is, my lord, annexed by the annexed in the criminal petition, my lord, filed by one of the co-accused, my lord, who is office staff.
What is this 233?
233 is, my lord, this is the authorization letter, my lord, issued by the Karate Association of India, my lord. My lord, may I read, my lord? My lord, through this, my lord, authorization, my lord, the Karate Association of India General Secretary has authorized the President General Secretary of Arunachal Karate Association to use the peshimel and digital signature of the General Secretary Karate Association of India, my lord. So, on the basis of this very authorization, my lord, the office staff of the one of the co-accused the office, who is office staff, he used the, my lord, that very Peshimer signature, my lord. May I read the authorization, my lord?
No, assuming that, no need to read it.
Yes,
So this authorization was given to the Arunachal Karate Do Association.
my lord.
And who said that by virtue of this authorization, I used,
My lord, that is the one of the co-accused, my lord.
where is that?
Co-accused is, my lord, that is, my lord, if we peruse the, my lord, criminal petition number 110,
Page
page number 152, my lord. 152,
142.
152, my lord.
Yes.
Yes, my lord, Farah 7, my lord. This is 152, 152, my lord. 152,
Yes.
my lord, may I read, my lord? Farah 7, my lord. That it would be inferred to state that owing to the outbreak of COVID-19 pandemic, temporary arrangements were made wherein the Persian and
What
General
happened to
Secretary,
this criminal petition?
my lord, state, my lord. Proceeding against this very particular accused person has been state, my lord. On the basis of this authorization letter, my lord. Here in this manner, in this Farah, my lord, this co-accused person has categorically stated he used the Peshimal and Skin digital signature of the General Secretary of Karate Association of India, my lord. After the direction by his authority, my lord, that is, my lord, President and General Secretary, Karate Association, Arunachal Karate Association, my lord. So that was his contention, my lord.
So whether it was not informed to IO during investigation,
Maybe, my lord.
you can raise it before the trial court.
But now, my lord, if we
Now
it's
on what
in-
ground,
on trial, my lord, if suppose, my lord, if
now on what ground you are seeking quashing of the proceeding?
my lord, that's why, my lord, this, since the person, my lord, the person who used the specimen signature, who used
No,
the
then, these
specimen,
are question of facts, who used it, how it was used, for which trial court is the best court. Apparently, to exercise powers under 528 of quashing, the guidelines are laid down in many of the apex court rulings, including Bhajan Lal's.
yes, madam.
So your case falls within which category out of those 7 category, or why the court should invoke its jurisdiction, inherent jurisdiction?
My lord, my contention is that, my lord, no offense has been made against me, my lord. As because, my lord, the statement of the co-accused person, my lord, is very clear, my lord. He is the one who used the
For all candidates.
for especially for the 8 candidates, for the petitioner, my lord. My lord, if we use
For these 8 candidates,
8 candidates, my lord.
where it is mentioned.
Specifically, my lord, he did not mention, but his statement is very clear that he is the one who used this.
Where is the stay order? You have annexed the stay
My
order,
lord, stay order is
page number.
number. My lord, 240, my lord. 240.
249.
240, my lord.
Two four nine.
Yes, no,
Your
240, my lord. 240.
Yes, Mr. Sharing.
My lord.
The allegation in this case is that they have applied form number 1 before the concerned authority. And after applying form number 1, they have been issued with form number 1, which is a requirement to submit for for interview. And that form number 1 contains the facsimile signature of the General Secretary of the Karate Association of India. That is the allegation. Now they have come up with a submission stating that they were, one of the staff was authorized by the Karate Association of India to use the facsimile signature, and that facsimile signature has been used, and they have been given form number 1. That is only their contention at this point of time. ma'am.
Then if what they are stating is true, then there is no offense,
Then no case, man.
no case
There's no
against
case
them.
against
They
them.
have a case.
In case if that is found to be true, then they have no case.
Mr. What is your name?
El Kurdu, my lord.
L
El Kurdu,
C K
Kurdu.
L Kudu, Learned Counsel for the petitioner. Also Mr. J Sharing, Learned Public Prosecutor, State of Arunachal. This criminal petition has been registered on filing of an application under section 528 of BNSS, 2023 for washing of. Now, whether it will not be under BNSS. We are treating it to be under 482.
Yes, my lord. I also mentioned, my lord,
Because BNSS, yesterday we discussed, BNSS uses the word, it is applicable only to Bharatiya Nyaya Sanhita, new IPC, not to all. BNSS
It uses the word Sanhita. It
Sanhita.
does not use the word Bharatiya Nyaya Sanhita.
Sanhita. Now what we mean by Sanhita does not mean
Sanhita
IPC.
has to be read as BNSS,
Yes.
not as a BNS. My understanding is slightly different. My
Okay. Let us see the. You are saying BNS, BSS. Sanhita means BNSS. You
BNSS.
may be right.
Sanhita.
582.
Five 528.
528, sir.
Nothing in this Sanhita shall be deemed to limit or affect the inherent power of the High Court to make such orders as may be necessary to give effect to any order under this Sanhita.
Okay,
So it has to be BNSS,
this, sir.
not BNS.
So,
There's no changes in the language of the inherent power, man. In the earlier CRPC, it says under this court,
so it only
confined to the procedural part.
recognizes the inherent power which
Only.
otherwise the court has.
Yes, man. That's all.
Then we may treat it as under 528.
528.
What was the last line? Filing of an application under 528 of BNSS by 8 numbers of petitioners, namely 1, 2, 3, 4, 5, 6, 7, 8. Praying for quashing of supplementary charge sheet number 05/2022 within bracket B under section 420/468/471/34 of the Indian Penal Code. Which has been laid in connection with Crime Branch PS case number 7/2021. Before which court?
Before my lord, Judicial Magistrate First Class,
Judicial Magistrate first class.
JMFC.
JMFC, my lord. JMFC UPIA.
JMFC?
UPIA.
No, charge sheet has to be filed before CGM only.
CGM. but I've seen it before JMFC, my lord.
It may be pending before
My lord,
JMFC,
must-
but
must
charge
have been-
sheet was filed before Chief
CGM, and it endorses to the
Okay,
JMFC.
before Chief Judicial Magistrate UPR. And presently pending before the Court of Learned Judicial Magistrate First Class UPR. Learned Counsel for the petitioner has submitted that the Crime Branch PS case number 7/2021 was registered on filing of an FIR by one Shri Kipa Kaha, President of Arunachal Taekwondo Association, inter alia Arunachal Taekwondo Association, before the officer in charge of Special Investigation Team within bracket SIT Police Headquarters, Itanagar, on 25 June 2021. Inter alia alleging that some persons, inter alia alleging that fake medal / participant certificate in Taekwondo has been used by certain persons to avail the reservation against meritorious sports quota in appointments. On receipt of the said FIR, the investigation was initiated and ultimately charge sheet was laid against 19 accused persons. Stop. However, the investigating officer continued with the further investigation. And after completion of and the investigating officer again filed the first supplementary charge sheet on 15/9/2021 against 6 accused persons with similar allegation in respect of sports, namely
Tenicoit, my lord.
Teli
Tenicoit.
Coit.
TENNIKOIT.
The investigating officer continued his further investigation thereafter also. And ultimately, he laid second supplementary charge sheet against 13 accused persons, including the above named 8 petitioners under section 420/468/471/34 of the Indian Penal Code on 28/3/2024. Learned Counsel for the petitioner has submitted that the accusation against the present petitioner in the second supplementary charge sheet filed by the investigating officer is that the petitioners have used facsimile / digital signatures of the General Secretary of Karate Association of India in form number 1 form number 1. What is form number 1? In respect of which
Madam, form number 1 is the certificate issued by the Karate Association of India, madam.
while for what purpose?
For my lords, this securing my lord government job, madam, under sports quota, madam.
Form number 1 submitted for securing government jobs. However, learned learned counsel for the petitioner has submitted that the petitioners were provided with the specimen signatures in form number 1 by whom? By Shankar Tama
Yes, madam.
and who is Shankar Tama?
My lord, Sankar Tamang is office staff of Arunachal Karate Association, madam. Office staff,
By
my lord.
by the employees of by the office staff of Arunachal Taekwondo Association.
No, my lord, Arunachal
Arunachal Karate
Do Association.
Do Association. And it is further submitted by learned counsel for the petitioner that the General Secretary of where is that authority? Karate Association of India
Page number 2.
by letter authorization dated 19/3/2020 had authorized the Karate Association of Arunachal Karate Do Association of Arunachal Pradesh to issue form number 1 to those sports persons who are entitled to same and sign it with the facsimile and digital signatures of the General Secretary of the Karate Do Association. Learned counsel for the petitioner has submitted that as the facsimile signature of the General Secretary of Karate Association of India was used by the officials of Arunachal Karate Do Association after getting due authorization for same by the General Secretary of Karate Association of India, no offense has been committed by the present petitioner as alleged in the charge sheet. It is also submitted that in this regard, 3 of the co-accused have already approached this court by filing another criminal petition and by order dated 30/7/2024 in criminal petition number 110/2024, a coordinate bench of this court has stayed the further proceeding of Crime Branch PS case number 7/2021 in respect of the petitioner number 1 of that case. Stop. What is your submission, Mr. Chen?
This stage, my lord, unless and until the
Records-
documents are being
records.
verified and the records are being called for.
Learned Public Prosecutor Arunachal, Mr. J. Shering has submitted that perusal of the case record of perusal of the charge sheets as well as supplementary charge sheet as well as case record of case diary of
Case diary may not be required, my lord. The scanned copy of the
scanned
supplement.
copy of the case
Supplement.
record of Crime Branch PS case number 7/2000, which case record?
Supplementary charge sheet number
7/2021 may be necessary for consideration of the instant criminal petition.
supplementary charge sheet number 5 of 2022, bracketed B.
Bracket V, my lord.
Case
Supplementary
record of
charge sheet number
supplementary
charge sheet
charge sheet.
number
5 of
5 of
2022,
2022
under
within
bracketed
bracket
capital B.
B,
under
capital B, in connection with Crime Branch PS case number
7/21.
7/2021 may be required. So in view of the submissions made by learned counsel for the parties, let the scanned copy of the aforesaid case record be called for. Registry to issue requisitioning. Registry to take steps for requisitioning the aforesaid scanned copies. Let this case be listed again after 2 weeks after receipt of the scanned copy of the case record. Stop. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, the further proceedings of Crime Branch PS case number 7/2021 in respect of the above named 8 petitioners whose name has been mentioned in supplementary charge sheet number
5/2022
5/2022
under bracket B.
shall remain stayed till next date of hearing of this case, list accordingly.
Deeply obliged, my lord.
Obliged,
I'm taking a short break of 1.
my lord.
Yes, what is this?
May, my lord, this is my lord,
You come before the microphone. Instead, you go little this side so that I can see.
yeah. Oh, oh.
Yes.
My lord, this is a joint criminal petition filed by the complainant and
Take the microphone.
sorry,
yes.
complainant and alleged accused person. It's a petition number.
Joint petition
Yes, my lord.
by
By complainant and alleged accused person as a petitioner number 1 and 2 for quashing of Narlagan PS case number 56/20.
341 and 324 are compoundable or not?
No, 24 is not compoundable, non-compoundable.
24 is not.
Yes, my lord. Earlier, actually, my lord, earlier the charge was case was registered under section 341 and 326. But after investigation, completion of investigation, 341 and 324 was charge sheeted against the alleged accused person. But during the framing of consideration of charge, only 324 was charge frame against the alleged accused person in this case. Hereafter, my lord, the case is pending for the prosecution evidence. And now, Your Honor, the matter has been already amicably settled. The parties, because they are close relatives. And moreover, the injury is a simple injury, my lord. Injury is a simple injury. Though the moreover, now the victim, actually the complainant is the elder sister of the victim. So now presently victim is no more also. Now no more.
Victim died,
Huh?
victim passed away
Yes, passed away.
because of this injury.
No, not of this injury. For some other ailment. Now they have lived peacefully without any grievances. So it is the intervention of the relatives only. The matter has been amicably settled, and now they have happily lived without any grievances, my lord.
But
So-
victim is no more.
Though he
The
is
compromise is not with the victim, but with the
with the complainant,
complainant.
she is the elder sister of the victim.
She is one of the witness.
Pardon?
Charge sheeted, in the charge sheet, her name is shown as one of the witness or not?
Yes. And because she's a complainant, definitely she's yes, one of the witness in prosecution witness. And now, my lord, the matter has been already settled outside the court. And now they have already happily lived without any grievances, my lord. So, my humble prayer, the case against the alleged accused
You
person will
have
be.
brought any authority to show that 324 can be
My lord, there's one citation, my lord. The case of Narendra Singh versus State of Punjab, my lord. In this case, my lord, section 307 and 307, 324, and
where is that case?
my lord.
Yes, Mr. Tado. Anything? Any submission?
Yes, it is, in Narendra Singh, it is there to compound the non-compoundable offense.
And when the matter has been amicably settled,
Yes.
what is your submission?
My submission is that since there is an additional affidavit I received that accuses as this is, victim is no more, and all the medical documents were and other relevant documents were buried with the body.
Buried,
Yes, as per culture apatuni customary law.
even if a case is pending.
Yes, it's personal documents, personal belongings. It is usually practiced in apatnik custom. So here, complainant seems to be elder sister of the victim. And this settlement I have gone through, it was,
There is some deed of settlement,
Yes,
that page.
page, my lord. Page
29.
29,
Yes,
annexure
Mr.
4.
Yes, what it says, deed of settlement.
settlement, it is, was done in presence of the Gaumbura of the village, that is village elders.
How the victim died?
My lord, actually on 1 September 2020, in the morning, she was found dead in the bed because as per the complainant, as per the elder sister, he was low pressure patient also.
Yes, Mr. Tado, any objection?
Objection, Your Worship. In such case, I like to leave it to the court, another court,
No,
to
you
pass
said-
any appropriate order.
Okay. Mr. What is your name?
Jitadi.
G,
Tadi, T-A-D-I,
E, A,
D-I.
G Tadi, learned counsel for the petitioner. Also heard Mr. G Tado, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been jointly filed by the petitioner, namely Miss Khoda Oka and Shri Bulo Sambeo, praying for quashing of criminal proceeding in GR case number 273/2020 under section 341/324 of the Indian Penal Code. Learned counsel for the petitioner has submitted that on when the affair was lodged,
25/4/2020.
that on 25/4/2020, the petitioner number 1, namely Ms. Khoda Oka, lodged an FIR before the officer in charge of Naharlogan Police Station, inter alia, alleging that the accused Bulo Sambeo, within bracket petitioner number 2, had assaulted the brother of the first informant and caused serious injuries on his person. So upon receipt of the said FIR, Naharlogan PS case number 56/2020 was registered under section 341/326 of the Indian Penal Code, and the investigation was initiated. Ultimately, after completion of the investigation, on 15/2/2021, charge sheet was laid against the petitioner number 2, namely Bulo Sambeo, under section 341/324 of the Indian Penal Code. Learned counsel for the petitioner has submitted that the victim, that is the brother of the petitioner number 1, has in the meanwhile passed away on
1/9/2020.
1/9/2020. Stop. And there has been a mutual settlement arrived at between the first informant and the accused, that is the petitioner number 1 and petitioner number 2 in this case. Stop. Learned counsel for the petitioner has also submitted that a deed of settlement has also been executed between both the petitioners on 2nd of August 2023, wherein it was agreed by the informant not to pursue the criminal case, as it was filed as a result of misunderstanding between the parties. It was amicably decided that both the parties shall live peacefully and affectionately and shall maintain peace and harmony amongst the families. Is there any relationship between the petitioners?
Yes,
What?
Malo,
Petitioner one and two, how
1
they
and
are,
2.
how they are related?
Actually, the wife of petitioner number 2 is the cousin sister of petitioner number 1.
The
Cousin sister.
learned counsel for the petitioner has also submitted, petitioners has also submitted that both the petitioners are also related to each other. And in view of amicable settlement arrived at between them, no fruitful result would come if the DR case number 273/2020 is further pursued. He has submitted that as it would be futile to pursue with the said GR case number 273/2020, it would be in the ends of justice to quash the said proceeding, so that the parties who have already arrived at an amicable settlement may live peacefully. Learned counsel for the petitioner has also cited a ruling of the apex court in the case of Narinder Singh and others versus State of Punjab, reported in 2014 6 SCC 466, where the apex court had allowed washing of a proceeding, a criminal case involving offense under section 307/324/323/34 of the Indian Penal Code on the basis of compromise arrived at between the complainant and the accused persons. Stop. Then additional public prosecutor has also submitted that in view of the compromise arrived at between the parties, no fruitful result is expected if the criminal proceeding is pursued, and therefore, for the ends of justice, this court may pass appropriate orders. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on records, including the deed of settlement executed between the petitioners on 2nd of August 2023. Stop. It also appears from the materials on record that the brother of the petitioner number 1, who was the victim in the case, has expired due to some ailment on 1st of September 2020. And the present petitioners are also related to each other. The petitioner number 1, who is the complainant, is also one of the main witness listed in the charge sheet. Main witness for prosecution side listed in the charge sheet. And in view of the settlement arrived at between the parties, this court is of the considered opinion that it would be futile to proceed with the case against proceed with the GR case number 273/2020 against the petitioner number 2, Shri Bullo Sambhyo. And this court is of considered opinion that for the ends of justice and to prevent the abuse of process of court, the GR case number 273/2020 is required. Proceedings of GR case number 273/2020 is required to be quashed, which this court accordingly do. Stop. This criminal petition is accordingly allowed, and the GR case number 273/2020 pending in the court of Learned. Which court it is pending?
CGM, Planet CGM.
Chief Judicial Magistrate,
Yes, yes, my.
where?
UPIA.
UPIA is against petitioner number 2, Bullo Sambhyo, is hereby quashed.
Highly aware.
What is there? Citations are. Oh, yes. No, this I require just a minute.
Please, my lord.
Just a minute.
My lord, this is, my lord,
Just a minute. Yes.
As per office note, your Lordship, LCR not yet received and service report in respect of R2
The POXO case,
is still awaited.
then the service has to be effected and the trial court scan copy would be required.
Yes,
We are fixing another date.
yes.
Heard Mr.
Arsenal.
R.
Arsenal.
R. Sonar, learned counsel for the petitioner. Also heard Mr. G. Tado, learned additional public prosecutor. On perusal of the office note dated 17/8/2024, it appears that scanned copies of trial court record have not yet been received, has not yet been received. Stop. Issue reminder for the same. Registry to issue reminder. Stop. It also appears that the notices issued to respondent number 2 have not yet returned and service is still awaited. Stop. Await further. Let this matter be listed again on. Second of September 2024.
Much of.
All the
Case lady was called for, but before that, my lord, there is an interpretation of section 27A of the NDPS, And I was checking up with the law, my lord have rendered 3 reported judgments and 111 unreported judgments in the NDPS only. And most of the judgments, my lord, have granted bail for delay in trial and fighting on the church. That I had gone through that Supreme AI, my lord, I had gone, my lord, kindly come to the FIR first. I just,
No, but case diary would be not required.
case diary is there.
It's there, your lordship.
Case diary is
Yeah.
there.
Yeah, it's there.
Before my lord peruses that,
Okay.
I request for 5 minutes to indulge in law.
Yes.
Well, kindly see page 11/4/2024, page 17 to 23 is the FIR. Well, type copy is at page 18 of the FIR. No?
Yes.
It is to inform you that on 11/4/2024, at around 1000 hours, an information was received from sources that 2 persons are about to bring heroin to Alo via Pasigat to Alo route. Accordingly, self along with SI P. Ungte Chapi, SI Marley Sora, so and so, conducted Naka checking at Gavu area, Logom Jini village, and at around 1400 hours, 2 suspected persons who were in blue-black color motorcycle bearing registration number so and so, identified as Kentong Ondir, aged 22 years, and Sri Jumgeng Ondir, to Kenli Doke, aged 23 years. So and so, so Pusi Doke Alo, were intercepted at Logom Jini, village near Gabu Alo, and upon their body search a blue bag containing 1 dark blue color soap case containing suspected heroin, weighs 8.72 grams, 2 1 green color so and so containing suspected heroin, weighing around 12.40 grams, around 1 gray so and so swab containing suspected heroin so and so. But only the sum and substance why I'm reading is that I was not apprehended from the place of from the Naka, and no seizure has been effected against me. The only
No.
allegation,
You were not apprehended.
yes,
From where it was
yes,
recovered?
from here only, my lord. One from a disclosure made by the one of the arrested person, my lord.
From whose possession these were found?
There's 2 boy, my lord, that
Kento and Kenli.
Kenli, my lord.
And your name is?
I am not named in the FIR.
No, but what is your name?
161. I'll come to that. Yeah, 161 statement Kakar. 34.
You are Neymar. Neymar.
Yeah. My lord, kindly come to page 35. Type
Page.
copy. The Kentong Omdir has made the statement.
Page.
Page 35. My lord.
35.
Type copy. Sorry, my lord, I'm not keeping well for last 10 days. Yeah. On being interrogated, I am to state that on 10/4/24, Kenli Doke called me saying on Asi, elder brother has some work at PI Colony, Alo, and to come early in the next morning. Early in the morning, we went to PI Colony near Government Secondary School, PI Colony, Alo. There we met Nyamar Asi. My full name is not there. Elder brother, he asks us to bring the drug heroin consignment from Assam, for which he will pay us some amount of money as commission and drug for our consumption. Then he gave us so and so. He told us that he had already talked to the dealer named Green at Cement Chapore, Assam, and we just need to pay the money and bring drugs to Alo. Then around 600 hours, we left for Assam in same Kenli Doke's motorcycle. On reaching Jonai, Assam, Kenli called the dealer Green, and he asked us to keep coming that route to Simon Chapore. There we paid him our money totaling 80,000 and took the drugs. When we were coming back to Alo via same Pasigat route, then the police caught us at Jini village. This much have to say. What is the full name of Nyamar and his address? I don't know the surname of Nyamar. He is from Kaing and stays near Pozer Resort. Now, my name, even they cannot. And then, my lord, kindly see my statement. Here, my lord will refer to section 67. 67 of NDPS Act. This cannot be a piece of evidence against me, my lord. Page 36, my lord, type copy is how they have recorded my statement. 37 is a type copy, my lord. My name is Nyamar Yang. I am 29 years, my lord. On being examined, I don't have to say anything. I don't know them. I did not give any money to anyone. I have never met them. I don't even know their names. How much money have you given to Kenli Dokhe and Kento Mamde? I didn't give any money. Question, do you know Kenli and Kento Mamdir? No, I don't know them, my lord. It's very clear, my lord. Even except for one thing, my lord, kindly come. This probably the accused was earlier used to consume drugs. That my lord will kindly come. Question one. From the bottom, my lord, second last questions. For how many years are you dealing drugs? The answer which he gave us, 2 to 3 years ago, I used to peddle drugs for about 6 to 7 months around Alor town with Sanu Sharma. Now I am not dealing with drugs anymore after Shillong incident. What happened at Shillong? My next page, my lord, kindly come. Shillong police caught me and Sanu Sharma with drugs 3 years ago. I don't remember the PSI, I think Molai PS. There I have stayed more than 1 month at lockup. Summon of trial still comes for that case. Are you drug user? I used to inhale drugs 2 to 3 years ago, but never inject it. Now I have left after incident at Shillong. That's there, his interrogations. Now, my lord, can on the disclosure of a person co-accused, that is what is there in the section.
Whether investigation is pending,
Yes, your lordship.
it is still pending.
Still pending, your lordship.
During pendency of the investigation, you get 161 statements.
But that is, no, my lord, there was 2 bail was already filed before
No,
the.
just I
this
want to know.
This is a very unfortunate incident.
How 161 statement are disclosed
I don't know, my lord,
before pendency
now
of
becomes a public
Yes,
document.
before filing of
It-
the
Yes,
charge sheet.
exactly.
It
your
is
lordship.
only after charge sheet
Correct,
is
correct.
filed and at the stage of 207 you are
Yes.
indicted, not before that.
Absolutely, your lordship.
Obtained from the court.
Your lordship, in fact, if I may just point out, your lordship, this is a very unfortunate case. Even in the CD, I have just flag mark it in the side, your lordship. An IPS officer who is from a very different districts call up the IO of the case and threatens him that why did you arrest this person? I have just flag marked this, your
Okay,
lordship.
we are not going into those.
Yes.
Anyway, my lord.
Now,
Kindly,
what
then-
are the materials
yes.
against?
Your
That,
lordship,
Your submission
why
is
is-
that apart from the statement of co-accused,
Yes.
nothing is there.
Nothing is there, and that section 67 of NDPS will come to my rescue.
Is there anything?
yes, your lordship,
Then-
your lordship,
The recovery was not made from their possession.
yes, yes,
They were arrested only on the basis of statement made by the co-accused.
oh, yes, your lordship,
Now, my query is, apart from the statement of co-accused,
yes, your lordship.
when were you arrested?
On 15/4,
How many days you are behind the
now
bar?
already, 127 days, my lord.
So in these 147 days,
Yes.
apart from the statement of the co-accused, have you collected, whether IO has collected any other material?
Your lordship, in fact, we have the questionnaire put up, your lordship. On the first occasion, he just lied that he does not have any other phone, your lordship. Mobile phone, your lordship. On making a search in his car, a phone was recovered, wherein
No, no.
your lordship will see the statement of the co-accused, to whom the alleged contraband was given is named as Green. I have not seen that person, your lordship. That contact number was found in the phone number of the co-accused, which was later seized on, your lordship. Now the co-accused has not been cooperating with regard to revealing the name of this particular green, your lordship, through whom the contraband was bought, purchased and was on the way being brought to the district, your lordship.
What was the quantity? 67?
Yes, this
It's 67 point,
commercial quantity, there is no dispute.
Not
Commercial quantity.
commercial. It is not
it's
commercial.
not,
If it is commercial quantity, I'll reject it
Yes,
immediately. If
no,
it
it's 21B, your lordship.
is not commercial.
21B, yes,
Yes,
21B.
21B, your lordship, it's, intermediate quantity.
Intermediate
Intermediate.
Yes.
So there is no embargo of 37.
Yes.
No
yes.
embargo, 37.
We are more particularly dealing with,
Now,
section
why do you
27.
need his detention for so long? 147 days.
Your lordship, as I have already made, given my submission that if this particular person, because we are not able to get the name, the supplier, is not cooperating with that, your lordship. The other point is, I have already stated, your lordship, which is also recorded in the CD, your lordship, I have like marked it, that there is an influence even from an IPS officers in different district, your lordship will see. He has been interfering in the case of this particular person, your lordship.
That is a different aspect.
Therefore, what my prayer is that if he is released on bail, your lordship, the trial hasn't started, your lordship. There are full chance that the present petitioner will in any way influence the
Now, who is this IS
Witnesses.
officer? If his name should be revealed.
that may not be revealed because it's in the CD, your
No,
lordship.
no, then that fellow should also be booked. He is not immune from the law. Why he should peddle?
No, then against that person
Yes.
who is interfering in the
In-
investigation,
Yes.
there are departmental forums to take
Absolutely.
action against them.
Yes. But then your lordship will see that he is an OC of a different district of,
No, but if there is evidence on record that he is interfering, then you
Yes.
file a complaint against him.
yes, my,
Appropriate.
yes, that the department will do, your lordship. My only,
Or should I direct,
your lordship can take a suo motu cognizance of that, because for me,
but not in this bail matter?
yes,
Not in-
because my concern is that because your lordship, the menace of drug,
No, not general statement.
not general,
Against this accused person,
this accused person, your lordship, will
what are the materials?
no material has been seized, or
Then-
except for the statement of his own, your lordship.
Then you cannot detain him any further. If there is no material. If for 147 days you are unable to collect evidence,
Yes, your lordship.
then we cannot detain him. We can impose conditions that he will cooperate in the investigation.
I'll leave it to your lordship.
Heard Mr. T.T. Tara, learned counsel for the petitioner. Also heard Miss T.G.
Ginny, your lordship, Ginny,
T. Ginny.
Ginny, your lordship.
T. Ginny, learned additional public prosecutor. This application under section. What is 27A?
27A is punishment for financing illicit traffic and harboring offenders,
Yes.
That is prohibited under section
your lordship.
NDPS Act. Then section
21B, 27A, 21B.
21B.
Oh, yes, I deeply apologize, your lordship. 27A comes under the purview of 37, your lordship.
is there material for 27A?
Except for the statement of the co-accused, your lordship,
Nothing.
there is nothing.
Then
Because the only, the evidence we could collect was the contact number of the person, particular person in his mobile phone. That's it.
क्या लिखा अभी तक? This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner. No, by who is Lingam Padu?
Wife.
by the applicant Srimati Lingam Padu for release of her husband, that is the accused, Shri Nyamar Riang on bail, who was arrested on 15/4/2024 in connection with Alo PS case number 26/2024 under section 21B/27A of the NDPS Act, 1985. Stop. It is submitted by learned counsel for the petitioner that the petitioner has been languishing behind the bars. No. ये line तो अभी इतना नहीं लिखा, पिसोट लिखी. The gist of accusation in this case is that on 11/4/2024, one Shri Lucky Mena, SI of police of Alo Police Station, lodged an FIR before the officer in charge of Alo Police Station, inter alia, alleging that on 11/4/2024, on receipt of an information through reliable sources that two persons are about to bring some heroin to Alo via Pasighat through Alo route, a search team was constituted and a Naka checking was placed at Gabu near Logumjini village. Stop. At around 2 p.m., the search team apprehended two persons, namely Kento NGO. How to pronounce this? NGOMDIR? Nomdir.
Yes.
Nomdir and one Kenli Doke, and recovered from their possession in 7 separate containers, within bracket soap cases, various quantity of heroin. The total recovered heroin weighed about 67.27 grams. So, learned counsel for the petitioner has submitted that the petitioner is innocent and is not involved in the FIR, not involved in the offense alleged in the FIR. He has also submitted that the petitioner was arrested only on the basis of statement of co-accused who were arrested at the spot. And apart from the statement of the co-accused, no incriminating materials are there against the present petitioner. It is also submitted by learned counsel for the petitioner that nothing was recovered from possession of the present petitioner, and he has been languishing behind the bars for last 147 days. And therefore, he submits that the petitioner may be allowed to go on bail. On the other hand, learned Ms. Chi Jini, learned additional public prosecutor, has produced the scanned copy of the case diary of ROPS case number 26/2024 and has submitted that the petitioner is involved in the offense alleged in the FIR. And though he has been detained behind the bars for last 147 days, he has not been cooperating with the investigating officer. It is also submitted by learned counsel for the petitioner that during the course of investigation, one high-ranking police officer posted in a
Different district.
where is the flag?
It's a flag mark in the side flag mark. Yes, that one.
Posted in a different district. Has tried to interfere in the investigation, which shows that the petitioner has links with higher ups in the police, and if he is released on bail, there is every likelihood that he will interfere in the investigation. And on that ground, the petitioner, the additional public prosecutor vehemently opposes the grant of bail to the petitioner. She also submits that as the case involves offense under section 27A, capital A of the NDPS Act, the embargo of section 37 is also applicable in this case, and hence the petitioner may not be allowed to release on bail. I have considered the submissions made by learned counsel for both the sides and have perused the scanned copy of the case diary of ROPS case number 26/2024, which has been produced by the additional public prosecutor in this case. Stop. On perusal of the case diary of this case, it appears that the petitioner, nothing was recovered from the possession of the present petitioner, and he was arrested about 4 days after the recovery of contraband from two of the co-accused, namely Kento Nomdir and Kenli Doke. Stop. It also appears that apart from the statement of the co-accused recorded under section 67 of the NDPS Act /161 of the Code of Criminal Procedure, at this stage, there is no other material against the petitioner on record. Stop. As regards the offense under section 27, capital A of the NDPS is concerned, it also appears that with regard to the alleged offense under section 27A also, apart from the statement of the co-accused, at this stage, there is nothing against the present petitioner in the case diary. It is now settled after the judgment of Apex Court in the case of Tufan Singh versus State of Tamil Nadu, reported in, which is the citation, reported in dash.
My lord, I have reflected in this Bindu Duri judgment, my lord, I have reported.
Where
There is
reported
bill
in so and so,
149.
that that the statement of co-accused recorded
Hmm.
under section 67 of the NDPS Act cannot be used as an evidence against an accused in a trial of involving an offense under NDPS Act 1985. Stop. Thus, moreover, the petitioner is detained behind the bars for last 147 days, which, in the considered opinion of this court, is sufficient period for during which the investigating officer could have collected some evidence had there been, could have collected some evidence. However, nothing is there on record. Stop. In view of above, this court, in view of above discussion, this court is of considered opinion that the materials in the case diary do not justify further custodial detention of the accused in this case. Stop. Hence, the petitioner, namely Naimar Rian, is allowed. Accused Naimar Rian. Wherever I have used petitioner, Amita. Accused Naimar Rian is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned. Which court? Special judge.
Sessions.
Special judge.
Session judge.
Session judge.
West Siang District, Alo.
West Siang District, Alo. With following conditions. Condition number 1 and 2. You will cooperate in the investigation. You will not threaten any witnesses. With above observation, this bail application is hereby disposed of.
Lordship, also with the condition that if and when necessary, he may, when sought by the IO, he may be able.
Third, condition number 3. He shall appear before the investigating officer of case number so and so, as and when necessary, and as and when required to do so for the sake of investigation by the investigating officer.
My lords, 3 judgment rendered by Lordship is Bindu Diori in bail application 149/20.
No, you give Tufan Singh.
The Tufan Singh's is like 2021 for SSC 1.
2021 reported in 2021.
For SSC
For
1.
SSC 1. Then below that Suresh also.
That's happened. Kesari is there.
Yes.
No. What to do?
Advocate was there today morning. Petitioner was there. But
We'll take up
but
tomorrow
now, time, possible for the time being, yes.
after something.
Arising out of same affair. Same connected case, starting portion. Oh, he came.
Yes.
So on the last occasion, the interim was granted.
Interim was granted.
And CD was called.
You appeared before the IO.
Yes, Lordship.
Your statement has been recorded.
Recorded, Lordship.
Yes,
In
Mr.
compliance with the notice given by the.
What is the offense?
Offense, theft in the dwelling house and mischief.
What is your stand?
Lordship, this is a civil matter, Lordship. This is a dispute, land dispute.
Yes,
And-
Mr. Tado. Oh, what is the submission?
CD, your worship, as per CD, that is
Whether his-
CD entry dated 4th August. Interim was granted on 25th July. Yes, 24th July. And on the strength of interim,
he
uh,
appeared,
accused appeared,
his statement has been recorded.
record date. But with the necessary instruction that whenever necessary, he may appear again. And as per the entry dated 4/8/24, that I put a paper plate that yes, orange one.
Yes.
Arrest is now felt necessary to recover the stolen properties and to identify the other co-accused.
What is your name?
This starting
Name?
is Kukut Talong.
Kukut Talom.
Yes. And there is a clear evidence, CCTV footage, that another paper plate I have put that not cooperating.
Yes. There is an allegation that you are not cooperating, you are not going to the, what is this 35S notice?
This is earlier it was section
41.
41A, yes. Same similar.
No, otherwise also condition, there must have been some condition.
In compliance with the notice, I have already appeared before the IO. Statement has been recorded. Page 19 of the petition is a copy of notice for appearance.
You appear before the IO again.
Yes, Lordship, definitely.
Why you need their arrest?
Because he is not cooperating.
Yes.
Stolen properties articles were not yet recovered. Stolen articles from the house. And the other co-accused mentioned led by this person were yet to be identified. He is concealing the fact. If Lordship may go to the records, Lordship, it's very clear that this is a dispute relating to civil dispute. Land has already been decided in favor of the accused person here. And cover this page number 50. Cover this. Whereas after complying this order, the applicant has come to the land to vacate the said land in compliance to this order. Now they have filed an FIR, and now there is also a title suit pending after this. So this is a civil dispute, and moreover, the contents of stolen property, they have gold bracelet and cash amount. The property where this incident happened, it was a uninhabited lot. There was no one there. And moreover, even if he has been kept in custody, there is no guarantee that the
Condition was not imposed actually. While granting interim, no condition was imposed. We are putting condition and making it absolute. Let them cooperate. Let him appear before the IO.
yes, IO instructed him to cooperate and
Cooperate means he should appear and give his statement.
yes, statement has already recorded, but
That means he has been cooperating.
but fact, another paper plate I have put on the CD. CCTV footage is was seized, and it is very clear that this person is involved in the commission of offense and stolen the property, loading in 2 vehicles.
Then if you have materials, you file charge sheet against him. If you have materials.
Unless
other co-accused are not revealed, their names are not revealed by this accused, and stolen properties are not recovered. If it is in the record, in the CCTV footage, and he is not disclosing the true fact, then IO will be helpless.
Then what will you do? So assuming that he is not disclosing,
Now means after arresting, he's going to torture to get the.
that I want to know.
Then it-
Suppose he is not disclosing, then what will you do?
Yes, arrest is necessary for integrations.
No, I will direct him to appear before you for interrogation. He will surrender himself before you. Whenever required, he will come to you for interrogation. You interrogate him.
Yes, same thing will happen. He will appear and
Then after
nothing will be disclosed.
after arrest, what will you do so that he discloses? What is your technique? After arrest, you employ some other technique which you cannot employ while he is on bail. I am not understanding. He will appear before you, you will interrogate him. Suppose he is not cooperating, he is not disclosing which you feel, then you have to collect evidence through some other evidence to implicate him.
Yes, this is a cognizable offense, Your Lordship. So cognizable offense doesn't need any warrant also.
No, no.
This
I'm
is
not
a
on
dwell,
that.
it's tapped in dwelling place.
No, no, I am not on that. I am because he has been once granted interim bail. Therefore, for cancellation of that interim bail, to vacate that interim bail, some strong reasons have to be there that he is misusing that liberty. He is threatening some witnesses or somehow misusing that liberty. Then I will cancel it. But suppose during interrogation he says that he is telling everything. You say that he is not telling. This will be always there.
Again, this accused was after granting of interim bail. Again, this accused was summoned, given notice to
Yes,
appear.
I have seen that you want him to be arrested because he has not complied with the notice.
Yes.
You comply with
Yes, no, should be.
that. You have, otherwise bail will be cancelled.
Yes.
Mr. What is your name?
T. Gatso.
T.
Gatso.
T. Gatso, learned counsel for the petitioner. Also heard Mr. G. Tado, learned additional public prosecutor. This learned counsel for the petitioner has submitted that by order dated 24/7/2024, the petitioner, namely Kukut Dalom, was granted interim bail by this court. And in pursuant to the directions of this court, the petitioner appeared before the investigating officer and he was allowed to go on interim bail. And his statement was also recorded under section 161 only. No, under section, what is the corresponding section of 161? BNSS. What is the corresponding section of 161?
161, it is. One eighty,
Under section 180.
80 BNS. BNS.
180 of BNS 2023. Learned counsel for the petitioner submits that the petitioner has cooperated in the investigation and is ready to further cooperate in the investigation and has therefore prayed that the interim bail granted to him by this court may be made absolute.
Your Lordship, it may not be made absolute now because,
No, no, I'm
yes,
yes, what do you want?
yeah, updated city may be called so that he's complying or not, we can.
On the other hand, Mr. G. Tado, learned additional public prosecutor, has vehemently opposed the making of interim bail as absolute on the ground that before that one line, Mr. Tado has produced the produced the case diary of Pasighat PS case number 95/2024, which was called for in connection with this case, and has vehemently opposed making the interim bail absolute on the ground that after getting the protection, interim protection by this court, the petitioner has not been cooperating with the investigating officer. He also submits that the stolen property is yet to be recovered and the CCTV footage collected during the investigation shows the implication, shows that shows the involvement of the present petitioner in the offense alleged. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record, including the case diary of Pasighat PS case number 95/2024. It appears that the petitioner has appeared before the investigating officer and his statement has also been recorded under section 180 of the BNSS, 2023. However, it also appears that on (25/7/2024), the investigating officer had served notice under section 35 of the BNSS for appearing before the investigating officer. However, it is alleged that the petitioner has not complied with the said notice and therefore, it is submitted by the additional public prosecutor that arrest of the present petitioner is necessary for his further interrogation. Stop. Stop. It appears that while granting interim bail to the present petitioner, no condition was imposed by this court on 24/7/2024. Stop. Though no condition has been imposed, however, it is implied when the interim protection is granted in a case where investigation is pending, the accused is supposed to cooperate in the investigation during the period when he is enlarged on bail. Stop. Considering the nature of the offense involved in this case and considering the fact that the petitioner was once enlarged on bail, enlarged on interim bail, however, no condition was imposed, comma, this court is of opinion that if some conditions are imposed while making the interim bail absolute, the custodial interrogation of and stop interim bail absolute, and if the petitioner cooperates in the investigation, comma, his custodial detention, custodial interrogation may not be necessary for fair completion of Pasighat PS case number. What is the PS case? 95/2024. So, in view of above discussion, comma, the interim bail granted to the above named petitioner on 24/7/2024 by this court is hereby made absolute with following conditions. The petitioner shall appear before the investigating officer once in a week for next 2 weeks, or till the investigation is completed, whichever is earlier, and shall cooperate. He will appear once in a week and shall cooperate in the investigation. The petitioner, next, the petitioner shall not directly or indirectly make any inducement, threat, or promise to any of the witnesses or any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before investigating officer. Any other condition you want?
Yes, if this order is not complied again, then he may be arrested. So that's why
If-
I
Yes.
made
If
submission
the-
that
if the- It is here, if it is hereby made clear that if the petitioner failed to comply with the above conditions, same may be good ground for cancellation of the bail granted to the petitioner. With above observation, this anticipatory bail application is hereby dismissed.
obliged.
Send back the case then. And in second case, 14, same
Arising out of same FIR.
Same affair.
Here-
The
order?
applicant, the applicant was not even present at the time. He was at,
No,
Vol-
okay, you also appeared, you are Doctor
Tariq Talon.
Tariq Talon.
yes.
You appear before the IO.
Yes, he is a name accused in FIR. Main instigator. Instigating the offense. This first accused in item number
Same-
13 is
same-
only his,
Same order, one more condition. He shall not indulge in any offense similar to for what he has been accused in the instant case. Other condition will remain same.
yes, remains.
Send back the case diary, this anticipatory. Change the name of the petitioner. Everything else remains.
Obliged.
What
The
happened?
Service on upon respondent number 2 is awaited, Your Lordship.
When have you taken steps? Any interim order is there?
No, no, seriously.
No interim is there.
No interim.
Okay. What will we do?
Your
Await
Lordship.
service or take fresh steps?
Yes, await service, Your Lordship, it has wrongly be shown in office note dated as respondent number 2. It ought to have been respondent number 4.
And against other respondents?
It has been completed.
Third, Mr. What is your name?
S. Iram.
S
Iram.
D I R A
Y I R A.
Y
I R A N.
Iram. Yes, Iran, learned counsel for the petitioner, also heard Miss T.
Ginny, your lordship.
T. Ginny,
Ginny, yes.
learned additional public prosecutor, who has pointed out that though in the office note dated 28/2024, it has been mentioned that service report is awaited in respect of respondent number 2. However, same has been a wrong entry, and respondent number 2 has already been represented by the additional public prosecutor. The service report is awaited in respect of respondent number
4, your lordship.
4 only. You take fresh steps. Stop. The petitioner is directed to take fresh steps for issuance of notice on respondent number 4. Where does he state 4? 4 by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this case be listed accordingly after 4 weeks.
Item number 16.
Your lordship, here on,
Who was the legal aid counsel?
she's absent, your lordship.
What is the name? Miss
H. Jeram.
H. Jeram.
Yes.
What should we do? What is the issue?
Your lordship, here on 22/8/23, your lordship, this honorable court has directed the legal aid council to make the statement regarding the delay. There is a delay of 263 days, so there is no aberment as such in the appeal also, the memo of appeal.
So the delay has not yet been
Not
condoned.
condoned, your lordship.
What is the offense?
It's NDPS Act, your lord, under NDPS.
But NDPS,
Yes, sir.
but he is unable to defend himself.
Yes, sir.
For legal aid counsel.
Yes.
We could have condoned the delay, but the counsel is not present.
Yes,
So we are fixing it on some other day.
yes, sir.
Third, Mr. P. Kete, learned additional public prosecutor. No one appears for the applicant. It appears from record that Ms.
H. Jeram.
H. Jeram was appointed as legal aid counsel for the appellant. Stop. It also appears from record that this appeal has been preferred after a delay of how many days?
263 days.
263 days. And delay is yet to be condoned. And appeal is yet to be admitted. Learned legal aid counsel is requested to take appropriate steps in this regard.
Yes, sir.
List this matter after
2 weeks, sir.
2 weeks on a date to be fixed by registry.
Deeply obliged, sir.
Yeah, your lordship.
You are for the petitioner.
Yeah, I'm for the petition.
What is your name?
And lordship, today I am submitting a
In the filing section, not here. You have to file the
Okay,
wakalat.
today I will file my wakalat as the earlier council has withdrawn their.
What is your name?
T. Kumbo,
T.
Kumbo, E-L-D-O.
Heard Mr. T. Pungo, learned counsel, who submits that he has been newly engaged in this case by the petitioner, and he would be filing his wakalatnama during the course of the day. Also heard Ms. T. Jenny, learned additional public prosecutor. Let this case be listed after a week. In the meanwhile, the council may file his wakalatnama during the course of the day.
Item number 18.
What is this, Mr. Yerang?
Services,
What is your title? Yerang.
Y-I-R-A,
How to pronounce?
Iran.
Yerang. Now, what is your submission?
Your we have taken step on
Services awaited. When have you taken steps?
3rd May 2020.
Why? Through registered post with AD.
Yes.
What is to be done? You submit the this postal tracking. They can submit.
Yes, Your Lordship, they have to take steps, yes, usual through registry also and through usual sources through registry, through police station also, concerned police station, Your Lordship.
Because till now, this is an case, almost 1 year has lapsed. Service has not yet been completed.
Yes.
What is the matter?
Your Lordship, they have challenged the FIR, quashing open FIR and the subsequent proceeding against the present.
Any interim is there,
Yes, Your Lordship.
therefore you are not taking steps. You take fresh steps. If you fail to take steps, interim would be vacated. Heard Mr. S. Geran, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. It appears from record, it appears from office note dated 12/8/2024 that notice is issued to respondent number 2 has not yet returned and service report is awaited. So it also appears that the petitioner has taken steps for issuance of notice way back in the month of May 2024. In view of above, the petitioner is again directed to take fresh steps for issuance of notice to respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. The interim order shall continue till next day, list accordingly.
Obliged, Your Lordship.
Yes. Valcode record has not yet received.
Yeah, TCR not
Received.
received.
Heard, Mr. What is your name?
T. Pavin, Your Lordship.
T.
I'm Pavin. On behalf of MS T.Y. Bhutian.
For the
Lordship,
petitioner side, Your Lordship.
for the petitioner.
Heard, Mr. T. Write his name. Appearing for Miss T.Y. Bhutia.
Yes,
Additional public prosecutor. It appears from office note dated 17/8/2024 2024 that the trial court records have not yet been received. Issue reminder for the same, registry to take steps. Let this case be listed again after. From where the records will come? It is UPI is.
UPI is
nearby.
here only.
List this case after 2 weeks.
2 weeks, yes. Sir. Deeply obliged.
Oblige you.
For the petitioner here. LCR or scan copy of LCR was sought for by this honorable court. That's it.
From which court? Pasighat.
Pasighat District and Session.
How much time will?
It ought not to have taken much time, your lordship,
Heard
because
Mr.
can,
V. Jamo,
Yes, Lord.
heard Mr. V. Jamo, learned counsel for the petition. Also heard Ms. T. Genie, learned additional public prosecutor. On perusal of the office note dated 28/2024, it appears that the trial, scanned copy of the trial court record has not yet been received. Stop, issue reminder for the same, registry to take steps. Let this case be listed again after 3 weeks. The interim order granted earlier shall remain till next day.
Item number 22.
What is this?
Yes, this is a joint petition for passing of the FIR, which is registered.
Record has come.
Yes.
Yes.
I think so.
We'll fix it for admission hearing.
Yes.
Your Lordship, I pray that the matter may be heard today and it may be discussed today.
No, it is in orders column
Yes.
for quashing of
Session case number 03/2024. On the
On what?
second,
on what ground?
my case. Yes. The ground that I have
No,
taken.
let us fix it for admission hearing.
Yes.
Can it be
We'll fix it on any date of your choice.
yeah.
This is a POXO matter, POXO case, and on the question of maintainability, I have raised on next day.
Maintainability of this application.
Yes,
Yes,
petition.
we'll hear that.
Yes, on that day, next date. It's-
If the case is ready for hearing,
Because they have come under joint petitions.
under 227,
No, 482, Your Lordship.
482,
482. And this is a joint
Your Lordship, although the.
or joint petition.
Yes, Your Lordship.
on the basis of settlement.
It is, Your Lordship.
You come up with some rulings.
Yes, Your Lordship, my case is different from the other settlements. The case that I'm projecting for Your Lordship is there.
Who is the victim?
The victim is Miss X, who is a minor girl, and the complainant is her father.
Father and daughter.
Yeah, the complainant is the father, who has lodged the FIR, and the victim is her daughter.
And who is the accused?
Which is the petitioner number 1, Mr. S.V. Docha Tagore.
We'll take it up on,
So,
you choose a date. We'll fix it for admission hearing,
Your Lordship, on
because he is raising the question of maintainability.
Yes.
So
Friday, Your
today
Lordship,
it is,
Friday on 23.
okay, Friday. Oh, is it okay on Friday? Third, Mr.
K. Taja. K. Ta- K. Taja.
Item number K. Taja,
Yes.
learned counsel for the petitioner. Also had Mr. G. Tado, learned additional public prosecutor. The trial court record, scanned copy of the trial court records, which was requisition, has arrived. And this case is ready for hearing. the learned counsel for the learned additional public prosecutor has raised the plea of maintainability of the instant criminal petition. Hence, let this matter be listed for admission hearing on Fridays.
Monday, 27, Monday. On Monday.
Friday, yes, 23.
Let it be on Friday,
Obliged, sir. Obliged.
23rd of August 2020.
That means day after tomorrow.
Like, yes.
Oh, like.
Item number 23 and 24.
If you may please, Your Lordship. My Lord, may I pray that this matter may be taken along with item number 33 of the supplementary list, Your Lordship.
Item number
33 of the supplementary list.
Where is the 33? What is 33?
My Lord, item number 33 has been filed for correction of IA number 131, Your Lordship. There was a mistake, typographical error in the course title of IA number 131, Your Lordship. And this IA 135, that is item number 33, has been filed for correction of the course title in IA number 131.
Okay, anything?
My lord, today I received an correction for in this case also the same mistake. Yadam, which one?
Where? In this case also there is a mistake.
Yes, epidemic is different in the method in the page number 3.
Which is the mistake? Tell me.
Yes, same. Name is mistake, my lord. Substitute.
Name of?
No, Your Lordship, in the course
No,
title.
let him submit.
Oh,
Name of?
Name of substitute, my lord. Page number 3, my lord. In the matter, an epidemic. Epidemic in Yagam and page number 3, Yagam.
Yagam Bogo. And in affidavit, what is the name? Now what is the mistake?
Mistake is my lord is Yadam.
No, you
Read
need
in
not to
Yadam.
show me. You have to tell what is the mistake.
Name of my applicant.
Name of applicant is Mr. Yagam Bogo.
My lord is read in Yadam in this my service copy. So my lord,
Service copy at page.
3, my lord.
No, but in court's copy it is okay. It is Yagam Bogo.
Yes, Your Lordship. My Lord, this
You have furnished a different copy too.
might be, Your Lordship. It's the same one. Actually, the substitution, Your Lordship. In the
Yes.
IA 131, Your Lordship, there was a mistake in the course title, wherein the relevant provisions were wrongly reflected, Your Lordship. The right provision would be under Order 22, Rule 3 of the CPC.
Heard Miss. T.
D. Tamuk, Your Lordship.
This is item number D. Tamuk.
Yes, Your Lordship.
Heard Miss D. Tamuk, learned counsel for, this is interlocutory item number. No, we are taking up 33 first. 33 first. Oh. 33, there might be mistake. What is your name?
Dalbong, my lord.
Oh, she has made correction by hand.
Yes, Your Lordship.
In the court's copy you have made, there might have been mistake in his copy.
That will be corrected, Your Lordship. I'll correct this copy as well.
You have to furnish actually corrected copy to the others.
Yes, sir.
No mistake is a small mistake. It is not relevant. Also heard Mr.
A Dalbong.
A.
Dalbong, my lord.
Talbom,
Yes, Dalbong.
Talbom,
Dalbong, my
T-A-L-B-O-N-G,
DONG.
Talbom, learned counsel for the opposite party. This application, this interlocutory application has been filed by the applicant Yagam Bogo, praying for correction of an inadvertent typographical mistake which has crept in the cause title of interlocutory application filed by the applicant for substituting his name in place of his deceased father in I number 131/2024. The learned counsel for the petition applicant has submitted that due to inadvertence in the cause title of interlocutory application number 131/131 within bracket AP/2024, instead of within inverted comma, you're right, an application under order 22 rule 3 of the Code of Civil Procedure comma 1908 for substitution of applicant Yagam Bogo as sole applicant in SAO being SAO within bracket C number 1 within bracket AP/2020. It has been wrongly reflected within inverted comma. It has been wrongly reflected as within inverted comma. An application and under order 1 rule 10 of the Code of Civil Procedure 1908 for implement of application for implement of applicant Shri Yagam Bogo as the sole appellant in SAO being SAO within bracket C number 1 of 2020 as a necessary and interested party. Same requires to be corrected. After hearing learned counsel for both the sides, it appears that the error appears to be an inadvertent and unintentional error, which, comma, for the ends of justice required to be rectified. So, the prayer for rectification of the cause title is hereby allowed. Who will rectify?
We'll replace the page number 1 in the IA 131, Your Lordship.
When we will take up 131?
Today itself, I'll replace it, Your
Who
Lordship.
will replace?
I'll
It
pass it to the registry.
it will go to registry again, or the court master can do?
The court master can replace it, Your Lordship.
Will direct you. You will replace the court master shall replace the corrected cause title furnished by the petitioner in I number 131/2024. This interlocutory application is accordingly disposed of. Then I number 131. You give the corrected copy. Where is the corrected copy? Give one only. Later on, you tag it with the record. Mention it as per order dated. You have anything to say? Nothing. This heard Miss D. Tamuk, learned counsel for the petitioner. Also Mr. Write his name. This application under order 2322 rule 3 of the Code of Civil Procedure, 1908 has been filed by the applicant Shri Yagam Bogo to substitute his name as appellant in place of his deceased father in SAO within bracket C number 1 within bracket AP/2020. Learned counsel for the applicant has submitted that the father of the present applicant, namely, what was the name?
Tumia Bogo, Your Lordship.
Late Tumia Bogo had filed the SAO number 1 within bracket AP/2020 under Order 43, Rule 1 within bracket small u of the Code of Civil Procedure 1908, impugning the judgment and order dated 18/2/2022 passed by learned District Judge West Sian Alo in title appeal number 2/2019 in connection with title suit number 7/2017. Learned counsel for the petitioner has submitted that during pendency of the aforementioned second appeal against order, the father of the present applicant, who was the sole appellant, had passed away on 14/1/2023 after prolonged illness. And as the present applicant is the sole legal heir of the appellant late Tumia Bogo, and he is interested in continuing the aforesaid second appeal, it is prayed that his name may be substituted as sole appellant in place of his deceased father. Learned counsel for the respondent does not object to the prayer. Hence the prayer is allowed. Hence the prayer is allowed. This interlocutory application is accordingly allowed. The name of the applicant, Yagam Bogo, be substituted as appellant in place of the deceased appellant, namely late Tumia Bogo. The registry to do the necessary substitution in the SAO number 1 within bracket AP/2020, and thereafter list the said SAO before this court after AB. This interlocutory application is accordingly disposed of.
Wait, madam, I am appearing as amicus curiae, madam.
You are ready?
Yes, yes. Subject to, if the learned it is in the public question to ready.
You are ready.
Yes.
Mr. Tado, you are ready.
Yes, ready.
I'll take a short break. This door is locked from inside or out? I'll take a short break of 1 minute, then we'll hear this.
Wait, my lord, this is an jail application. appeal filed by the accused.
Your name is Mr. Tayoum Son.
Time zone. So this,
Where is the paper?
so this jail appeal is arises out of the judgment and order passed by the learned special judge Teju, Arunachal Pradesh, man.
Teju?
Teju. The judgment was rendered on 10/2/2022.
Yes.
Well, here in the appeal, Malan, only 4 grounds.
No, what was the allegation? Where is the FIR?
FIR copy is as per the paper book.
Paper book.
Paper book. It is 8 page. One. To the, may I read this, madam?
Yes.
To the officer in charge, police station, Namsai, district Namsai, subject FIR. Sir, it is to inform you.
In that regard, I will just proceed further. The statement before the magistrate was recorded after 1 month of the incident, and he is an interested witness in the case. Kindly note, interested witness in the case. Other than this witness, none of the witness has taken the name of these 2 accused to be assaulted. Yes, sir. Thereafter, my lord, may I come, my lord, now page number 20. Findings of the court, learned court. This is the findings, ma'am. May I read, my lord?
Yes.
As regards A2 and A3, my lord. These are the private respondent hearing, my lord. This court, after minutely perusing the materials on record, has found that although they were alleged to be part of quarrel that took place between A1 and John Tapping, who later called the disease for his health, but could not find any materials from where it can be gathered that they were party to the physical fighting between A1 and the disease. Now, my lord, the only witness who stated that A2 and A3 were also assaulted the disease is John Tapping, who called the disease. Although this witness has not stated anything to that effect before the IO, but he has improvised his statement by stating the same before the magistrate, which is recorded after 45 days of the incident. This is the person with whom A1 initially fought with, and also alleged that A2, A3 also supported the A1, because of which this person called the disease for his health. Therefore, he is an interested witness. As such, only on the basis of the statement of this witness, as the remaining eyewitness of the incident, including a girlfriend of these witnesses, has not named A2, A3 to be the party to physical fighting between A1 and A0. This apart, there is no any other material to indicate the participation of these 2 accused in physical fighting between A1 and disease. Therefore, this court is the opinion that the trial against these 2 accused will be unnecessary and futile. Hence, A2 and R entitled for discharge on the ground of insufficient material evidence. Accordingly, this order that A1, A2 San Mosu, A3 Doikomi are hereby discharged from the case. Therefore, they shall be released from the jail for which so and so and so. Now, my lord, this is the improvement. Now, basic my lord, case is, my lord, that parameters of 227 says, my lord, not only metrics, even, my lord, strong suspicion is
yes,
my lord.
discharge 227, my lord. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reason for so doing.
How this phrase, not sufficient ground for producing has been,
My lord, that's why, my lord, why my case.
what is the meaning of this?
Yes,
Not sufficient ground for proceeding.
not sufficient ground, my lord. My lord, I have some judgment on that particular aspect, my lord. Basically, all the judgment is saying, my lord, that sufficient ground, my lord, this has to, what has to come of the opinion that there is no prima facie case, my lord. This satisfaction has to be there that there is no prima facie case at all against the accused person, even if you take entire the materials on record as it is, my lord. Now, and the, my lord, principle of law says, my lord, even strong suspicion is enough to, my lord, leaving apart that one, my lord. Now the question here before this, whether this exercise of power in the manner in which, my lord, this analyzes this evolution of the witnesses has been the statement of them, whether this is legally permissible under, my lord, while considering this power, exercising power under Article 227. The law says, my lord, no. We cannot go to the reliability and probability value of the statement of the witnesses at this stage, my lord. It has to be taken at its face value, my lord. That can be challenged only after, my lord, cross-examination, my lord. Now, this is the case, my lord, if this evaluation is done, my lord, even before, my lord, allowing the witness to adduce the evidence before cross-examination, my lord, it is something, my lord, mini trial has been done, my lord. That he has evaluated the all the witnesses, saying that whether it is credible, is an interested witness, why he cannot be relied, my lord. This reliability cannot be entered into question. Only what can be entered into only, my lord, is the broad probability and improbability of the case, not of the, my lord, reliability of the witness at this stage. We have to take the statement as it is made. My lord, may I cite some judgment in my support, my lord, which deals with 227, all those things.
This is item number 29.
28, my lord.
28.
Look, citation number 2022, 12 SCC 657, my lord, page number. Para, my lord, 16, 18, 19, 21, 22, 23, 25, 26, 27, and 28, my lord. My lord.
Which is the main paragraph.
My lord, I'll just. My lord, there are 23, my lord. 23, then 27, my lord. Basically, this judgment is saying, my lord, 227, my lord, this holding of mini trial is not permissible. And probability value of the statement of the state witnesses cannot be entered into, my lord, at this stage, my lord. Next session is regarding groundless matter. 2022 SCC online SC 1150 matter. Start from para 51 matter onwards matter. All these aspects has been here matter. Para 51 matter, then 53, 54, 55.
Which para it deals? No, in this judgment, what has been stated?
My lord, in this judgment, basically is saying, my lord, so far this 227 is concerned, my lord. Para 53, may I read, my lord, para 53?
Yes.
The primary consideration at the stage of framing of charge is the test of existence of prima facie case. And at this stage, the probative value of materials on record is not to be gone into. My lord, once there is a statement of popular witness, once he has said that these 3 persons have assaulted. Now the question before us, my lord, can we examine whether I should rely on the
So
statement of
this judgment is saying that at the stage of framing of charges, the probative value of the
materials
cannot be gone into.
This how we can say
That is your main thrust.
main case, madam.
And in this case, the trial learned session judge gone into the question of reliability
Yes, and declared that he is interested.
and that he is not reliable in spite of the
He has used the word my lord,
interested witness.
interested. How this conclusion can be arrived, my lord? Is it permissible under the law to come at this stage that to make a finding who is interested or not? Learned trial court was very much influenced by the fact only because he was the friend, my lord. And it's all happened because of him, my lord. He was a injured witness. First, he was assaulted badly, my lord. So, my lord, these two judgments basically I am trying to show, my lord, what are the parameters and scope of 227? What are the materials that has to be looked into? And how that analysis evaluation has to be done? All, my lord, other judgments have been dealt in this judgment also, my lord. I will just read one more, my lord, paragraph, my lord, para 75, my lord.
This was in respect of a warrant procedure case.
Yes, my lord. Here in this is, Apex Court is saying, my lord, either 239 to 70 or 227 to 220, my lord. Otherwise, my lord, the principles are the same, my lord. That how is, for consideration of charge, my lord, what are the materials to be taken into consideration? Maybe some words are different, my lord.
These words are important.
Yes, my lord.
In 239, the word groundless is mentioned.
Yes, yes.
In 227, the word not sufficient ground for
Not
producing.
sufficient ground.
So we have to find out whether there is sufficient ground for proceeding or not.
Yes, ma'am.
Is there any judgment which you have cited or on which you are relying, which shows how this phrase not sufficient ground for proceeding is interpreted by the Apex Court?
These two judgment, my lord, basically it has deal with this section 227 only, my lord. 227 only basically, my lord. Saying that para 55.
paragraph 55, my lord. May I read, my lord? The aforementioned section indicates that CRPC contemplates discharge of the accused by the Court of Session under section 227 in a case trial by cases instituted upon a police report are covered by section 239 and cases instituted otherwise are. The three sections contain somewhat different provision in regard to discharge of the accused. As per section 227, the trial judge is required to discharge the accused if the judge considers there is not sufficient ground for proceeding against the accused. The obligation to discharge the accused arises when the magistrate considers the charge against the accused to be groundless. The power to discharge under section is when the magistrate considers for reason to be recorded no case against the section 227 and 239 specifically provide for discharge being made before the recording of evidence and consideration as to whether the charge has to be from frame or is not required to be made on the basis of the record of the case, including the documents on oral hearing the office and prosecution of the so-and-so. Para 56. Despite the slight variation in the provision with regard to discharge under the three pairs of section referred to above, the settled legal position is that the stage of framing of charge under either of these three situations is a preliminary one, and the test of prima facie case has to be applied if the trial court is satisfied that the prima facie case made out charge has to be framed. My lord, the word then para 57, my lord. May I read, my lord, 57 one?
That is, the materials are to be taken at their face value.
Yes. The nature of evaluation to be made by the court at the stage of framing of charge came up for consideration of this court in so and so and so and so, and referring to its earlier decision in the state of so and so and so and so, it was held that at that stage, the court has to form a presumptive opinion as to the existence of the factual ingredients constituting the offense alleged, and it is not expected to go deep into the probative value of the materials on record. My lord, as it is basically it's said. Yes. Now, my lord, another judgment, my lord, is 1981.
Some other point or same?
Other point. This 1981, I am saying, my lord, who is interested? There are 7 on them. Hello, he cannot be said to be interested. This finding itself is flawed. Why I am saying? Hello, he is either a natural witness. He is a natural witness, my lord. He has no any something motive as to make the false accusation against any person. My lord, his presence is there. It is because of him only all this incident happened. And he should be the one of the most reliable and the most natural witness of the case. That's why, my lord, just to show, my lord, that he cannot be said at all present witness. Otherwise, even that evaluation is not permissible under the law at this stage. Then, my lord, then, my lord, this witness, this, my lord, para 3 and 5. Why I am submitting this judgment is, my lord, that is saying that even if we say, my lord, he is the interested witness, assuming. Now, law says, my lord, the witness, evidence of the interested witness also cannot be thrown away like this. It has to be, needs to be carefully evaluated. Without evaluation, my lord, for example, let's assume forever, he is interested, even assume. But before even the start of the trial, my lord, this evidence cannot be just thrown away
at the initial stage itself. Even after the trial, even my lord, what the law is saying, my lord, you, even if you see that somebody is interested in this, you evaluate his evidence very carefully. But it is, we cannot just come to the conclusion that he is interested, I will show, but this is for that purpose. Now, my lord, about this sole witness. Now, even if you say, my lord, he is only the one eyewitness. But the law, my lord, so far our criminal law is concerned, we were saying, not saying that the,
Para?
my lord, para 2:7, 2 to 7, my lord, and 14 and 19, my lord. My lord, because quantity is not required, my lord. Even suppose, my lord, tomorrow we find this injured witness is reliable, it's sufficient now. I don't want, my lord, all the witnesses should see the incident. Not necessary, my lord. That is required, my lord. If this person is saying, my lord, then, my lord, one last judgment. Evidenceary value of the injured witness. How a evidence value of the injured witness has to be given priority. The case court is saying that injured witness value is in a high pedestal. Para 26, one only, my lord. With this, my lord, with this, my lord, I conclude my submission, my lord. Only that, my lord, that scope and parameters have been crossed in this case, and perverse, my lord. Because one side he is saying, my lord, that one of the witness has stated that 3 of accused has assaulted.
Still he is saying that there is no.
Again said that there is no material. How this is contradiction? With that, my lord.
Yes. What is the submission of state?
Your lordship.
You are supporting the petitioner or the respondents?
I am supporting the, since the state has not preferred this revision, your lordship, meaning thereby, your lordship, it's impliedly, your lordship, the state is in favor of the order which has passed by the learned trial court, your lordship. The material whichever has been considered, your lordship, because, your lordship, no doubt, learned senior colleague had rightly pointed out that at this stage, the mini trial cannot be held, your lordship. However, your lordship, after taking cognizance of an offense, at the time of taking cognizance, the court has to see whether prima facie offense has been committed or not. And after that, the court's duty is to find out an accused who really is involved. It's not about the conviction, but who are involved in this offense, your lordship, considering all the material on record. And it cannot do in a pick and choose basis, your lordship.
Before us is that when one of the witnesses on record under section 16, in his statement recorded under 164 says
Yes, your lord.
that I have seen both the accused person assaulting him, then whether at the stage of framing of charges or at the stage of 227, court can go into the reliability question of reliability, probative value of that.
Yes, sir. On probative value, your lordship, I will rely some judgment on it, your lordship, but question here is, your lordship, the fact and circumstances of all the cases has to be considered by the magistrate, your lordship. It's not because, your lordship, simply he has been injured. No doubt he was there in this couple. He was the person present there, but, your lordship, it has to be looked into
Where
from
is the 164 statement? 164 statement, page.
My lord. Piece number, my lord, 47, my lord. Then, my lord, 48, my lord, you find. 47 and 48, my lord. Relevant portion, my lord, page number 48, my lord. My lord, first paragraph from the bottom, 4th line, man. First paragraph from the bottom. May I read, my lord? After some time, my friend Let Khoda Tame came to the spot, and the deceased person is Khoda Tama, my lord, came to the spot, and he saw me and was talking to me, and on seeing him, the 3 boys attacked him and beat him. My friend was trying to defend himself and they kept beating him till he went inside the house gate. I tried to stop them, but Mosu had punched me once again. I was also injured. I could not be of any help to my
As
friend.
a result of this assault, he died later on, or on the spot.
I think he was immediately evacuated, but he became unconscious at this stage.
Okay, okay. At page 48, Mr. Ete.
Yes, your lordship, before coming to that, your lordship, now my learned brother is only pointing on the statement of one John Tapping, your lordship. It is a fact that, your lordship, there was a quarrel between this present accused, the person who has been discharged, and the person who has been under trial now, your lordship. Now, before that, your lordship, I would apprise your lordship that now this case is on the stage of your lordship, defense witness, your lordship.
Defense witness.
Yes, your lordship.
Why after, when have you filed the
Well,
petition?
this was immediately filed, my lord.
Within limitation, period of limitation.
My lord, delay was there of few days only, my lord.
That was condoned.
Condon.
So now, your lordship, the one of the issue, I will come to that, your lordship, but the issue here is, your lordship, basing on all this material, the trial is been going on.
This
your
was
lordship.
filed in
No doubt, your lordship.
2022, my lord.
Now, your lordship, at this stage, if there is a material, the petitioner's side, they are not remediless. Section 319 is there, your lordship. If there is a evidence against the two discharge accused, because discharge accused can again be, your lordship, aired as an accused under 319. It's been clearly laid down by the Honorable Supreme Court, your lordship. So now, basing on the material whichever has been collected during the course of investigation, the trial has been conducted. The trial is going on, your lordship. Now, evidence, everything has been recorded. There is no any evidence as such as on that, which is of that causal nature. If,
No, but because he was not, they were not charged. The prosecution did not deduce evidence against the person who is not facing the trial. Once they were discharged, prosecution will lay the evidence only who is faced against the accused who is facing the charge. So this argument that there is now during trial no evidence has come up
and
may not be very.
And your lordship, at the time when the incident has happened, he was not only the sole eyewitness, ocular witness. There are other people also there.
No, that is my question.
Yes.
When there are 3 or 4 witnesses.
Yes, your lordship.
Giving contradictory statement.
Yes, your lordship.
One accusing some person A, other accusing B. Then whether you can discharge B on the ground that some of the witnesses have not implicated you.
Your lordship, here the doubt, what was created, your lordship, what I'm trying to submit is, your lordship, initially the scuffle was, the quarrel was between this statement, your lord, the accused who has given this statement on 164. Later on, he called up the deceased person, your lordship, to come to the place of occurrence, wherein sudden fight occurred, and the person who came to the place of came to that place, he died. Ultimately, he succumbed in the hospital itself, your lordship. Now, your lordship, we cannot consider the statement of this accused as a injured witness at this stage, your lordship, because while considering
Actually, that witness has not yet deposed before the court during trial.
yes, your lordship.
So to assess the probative value of that witness,
Yes, your lordship.
stage is not the appropriate stage at the stage of framing of charges.
Yes, your lordship.
Now, that is the question to be decided in this revision petition, that if there is material, apparently some incriminating material against some of the accused, then whether at the stage of charge, at the stage of 227, court can go into question of reliability of that material, that though there is material, but it is not believable. Whether
Yes.
court can go into that.
Yes, your
question.
lordship. At the stage of consideration of the
The
offense.
judgments which the petitioner's counsel has cited all says that at this stage of framing of charges, probative value of the evidence
Yes, your lordship.
on record cannot be gone into.
Yes, your lordship. That is there, your lordship.
So if we go into probative value for discarding the evidence of this person, some reasoning has to be given,
Yes.
which the court has given, why it is not relying on.
Yes, your lordship.
But the plea of the petitioner's counsel is that that exercise could not have been taken at that stage. The stage is later stage during trial when he is cross-examined.
And your lordship, so far as the record is concerned, because at the time when the charge is framed, the court has to presume whatever material has been produced by the prosecution is true at this stage. So now, your lordship, 161 is also the part of this material, your lordship. So now, your lordship may kindly come to 161 statement of this present accused, your
He
lordship.
has not stated.
Not stated, your lordship.
There is an omission.
Yes, your lordship. And it's,
But that omission has to be again brought to his, that exercise during cross-examination has to be taken up.
yes, contradictory value, yes, that is there,
Or
your lordship.
not relying on his
Yes.
statement. We don't know what he would have stated before the court during trial.
And your lordship, so far as your lordship, at the stage of considering the framing of charge, what court is required to see whether there is a ground to presume that the offense has been committed and not whether a ground to convict the accused has been made out, your lordship. So whether there is a ground or not, your lordship, whether this will be the sufficient one. It says ground, your lordship, and to support my submission, I would like to, your lordship, rely the.
Sufficient ground.
Yes. Your lordship. Because, your lordship, it's at this stage, because other witnesses who were also there, the court has to see at the time of inquiry all the material which has been placed before the court. And after seeing all the material, your lordship, this applicant is the only person who has stated, and that too are in the 164 statement, not in the 161 statement, and 164 statement was recorded after 47 days of incident. This is one of the aspects, your lordship.
But he is stating on oath
Yes, that is there, your lordship.
before a magistrate.
And-
Its value is more than 161 statement.
Yes, and your lordship, so far as the injury witness is concerned, no doubt, as my learned senior colleague has stated, it has to be kept in the higher pedestal value. But so far as this present applicant is concerned, your lordship, because of him only that person come on the spot, your lordship. And your lordship, this petition, criminal petition has been filed by the father, your lordship, father of the deceased person. And this present, your lordship, not the applicant, your lordship, this is not the applicant, in fact, applicant is the father, your lordship. The statement which my learned senior counsel is relying, your lordship, because of him that incident has happened, your lordship. And considering that aspect, the learned trial court has reflected that he has an interested witness. And no doubt, your lordship, even if he is considered to be interested witness, it cannot be discarded in total. The court has to properly scrutinize and appreciate before come to a conclusion to rest upon it, your lordship, regarding the guilt of the accused or not. For making proper scrutiny, your lordship, some corroboration must be there. How court will scrutinize, your lordship, the statement given by the interested witness, which purportedly considered as an interested witness. The other material, the other person who were present, who were eyewitnesses, they have only deposed regarding the assault by other person. None of them has ever stated that this person, the charged person, they have assaulted the accused. Only this person, that too on the 164 statement. No doubt, your lordship, that is a subject matter regarding contradiction. But your lordship, regarding reliability, because ground exists or not, your lordship, whether it's afterthought, at that stage, even afterthought is not required to be considered, but ground, your lordship, the ground, whether it will be sufficient ground to proceed with this accused who has been discharged or not.
Okay, Mr. Sonar, one query. Suppose one of the witnesses names you, names X, a stranger. No other witnesses, and X is nowhere in the picture. But he states before the magistrate on oath that X has also assaulted.
Yes.
In
But,
that
but
case, my
there
lord-
are no other witness.
Yes. In
Then
this-
whether X has to be compelled to face the trial because one of the witness has, or whether can he be discharged?
If the material shows that the presence of X is improbable, if the material shows. Then-
Improbable.
If it is improbable, then saying of a single witness, we may not rely on this. But our case is quite different. man.
It is not. of-
Presence is not in dispute. But now, I will, my lord,
Okay, okay, I have understood.
I have another materials also, my lord, here in my case. Two materials, they are saying only statement of injured witness. In my case, my lord, in the record, my lord, I will show, IO in his conclusion, my lord, kindly turn to page number 20. But the learned session judge has not considered the findings of the IO. Page number 29, my lord. My lord, here I will show that IO has deliberately not recorded that statement about this particular, or he might have forgotten. I won't say deliberate, my lord. Page 29, my lord, from the bottom, from the second paragraph, last line. This is the finding of IO, my lord. Page number 29. Two other alleged accused person, namely so and so, denied their involvement in this. But my lord has got. But witness Mr. John Tapping, Elias Tapping, has stated that he had seen those persons assaulting the victim. I will pause here. If why IO has not recorded, my lord, this statement? He has reflected in his finding. My lord, what I mean to stress the point. 161 is recorded by the IO. Then IO was informed. Where is the contradiction even, my lord, in my case? My lord, they are trying to build up this case. Can we, my lord, leave the case in the hand of IO? Tomorrow, suppose, my lord, if IO, my lord knows that in 161 statement, even the witness need not to put signature. Its value is only for contradiction. It's not even evidence, cannot be used as evidence. This is the case.
Let
One more, last. Another 164 statement, he has also said. Now they are saying only one witness, that is contrary to the record. After that, I will.
Another witness.
Another witness also has stated, 164. Kindly turn to page number 50.
50?
50, my.
Who is that witness?
Witness is Yami Komi Nyogem. From that third paragraph, my lord, I will start from the bottom.
Yami is male or female?
This is female, my lord. Miss Yami Komi Nyogem. Page number 50, my lord. Para 3, from the bottom, I will start. Para 3, my lord. 1, 2, 3, 4, 5, 6, 7. 7, my lord. 8, after they left, my lord. Married, my lord. Third, 3, my lord. Third paragraph, my lord. Then from the bottom, 1, 2, 3, 4, 5, 6, 7, 8, my lord. Married, my lord.
Yes.
After they left, I heard noise outside the house. After son, this is son, finished his food, he also immediately rushed to the spot. So I went to the ground floor and saw Tanu and John fighting each other outside the gate. The area is visible due to the lighting of the. I saw that even son is one of the respondent here, my lord, who has been discharged. I even saw that son joined the fight with the other boy who had come with John, my lord. Son is the, my lord, here, private respondent number 2. A2 accused number 2. Now what is saying, man?
Who is the deceased? Tanu?
Tanu is the A1. For him, my lord.
John is the deceased.
My lord, John is not deceased. John is the injured witness. Kyoda Tama is the disease, my lord. Now what he is saying, my lord, may I read, my lord? I saw that even son joined the fight with other boy who had come with John. Who had come with John means what, my lord? Kyoda Tama, the disease. Because I came to rescue, my lord. At that, I will read onward. At that time, I did not see Komi fighting with any of them, but I did not pay attention to where he was at the time. The rest of them were all engaged in physical fight with each other. Even with this, my lord, these are the matters I will see that my friend.
So regarding your lordship, the involvement, John Tapping, your lordship, who has stated in the one.
Tapping is A1.
Yes, yes, lordship. No.
Tapping is
Injured.
Injured witness. They have stated him to be the injured witness, but it was a group fight, your lordship.
But he is one of the listed witnesses in the charge sheet.
Yes, yes, witness of the charge sheet, your lordship.
He is one of the witnesses.
Witness, your lordship. So this is the fact that he was the person who called the deceased there, place of occurrence. And sudden fight has happened, and ultimately, your lordship, untoward incident has happened. The deceased died, your lordship. So now, your lordship, before relying on, I was on that, your lordship, before relying on his statement, your lordship. Now, whether his statement can be relied upon or not, your lordship, because he is one of the in my humble understanding, your lordship, he definitely, your lordship, if he has a benefit, your lordship, if either benefit from the outcome of the proceeding, your lordship. Why? Because, your lordship, because of him, the victim came there, and no doubt, your lordship, he has a guilt of that because of that incident, because of his action. The offense or ultimately the deceased succumbed, your lordship. There was sudden fighting and died. The victim was nowhere else there at the particular point of time when all of them were met there at the place of occurrence, your lordship. He called him up there. Incident happened, and later on he has given the statement before the police where other eyewitnesses' statements has also been recorded. They have not given in their statement identifying both these two accused, discharged accused, but only the John Tapping letter before the magistrate under 164 statement, your lordship. So which was not found to be sufficient ground to presume that both the discharged accused were committed the offense. On that ground,
So how explain the observation of the apex court that probative value need not to be examined at that stage?
Your lordship.
One problem may be there. Suppose we don't examine the probative value.
Yes, your lordship.
Then if before framing of charge sheet, filing of the charge sheet, the IO has to apply his mind.
Yes, your lordship. Your lordship, the judgment I would like to refer where the Honorable Supreme Court that all has to be recorded on its probative value also. This is one of the judgment. This is Tarunjit Tejpal case, your lordship. The guidelines regarding, your lordship, what aspect has to be considered. Reported in 2020, 17 SCC, 2017 SCC 556. Enough of judgment has been considered altogether there, your lordship. Where is
2020 17 SCC
2017 SCC 556, your lordship.
556. What it says?
Your lordship, I will directly come to para 8, your lordship. May I read paragraph 8, your lordship, page number 566. Now, so far as the prayer.
566.
Yes, 566 page number, your lordship. The relevant para, page number for relevant para, your lordship. Now, so far as the prayer of the appellant to discharge him and the submission made by Sri Vikas Singh, so and so on merit are concerned, the scope of the stage of section 227 and 228 CRPC is required to be considered. Here, your lordship, all the aspect has been considered. In N. Suresh Ranjan, this court has an occasion to consider in detail the scope of the proceeding at the stage of framing of charge under section 227, 228 CRPC. After considering the earlier decision of this court on the point, thereafter in para 29 to 31, this court has observed and held as we have bestowed our consideration to the rival submission and the submission made by so and so commend us. Through it is that at the time of consideration of the application for discharge, the court cannot act as a mouthpiece of the prosecution or act as a post office and may shift evidence in order to find out whether or not the allegation made are groundless so as to pass an order of discharge. It is true that at the stage of consideration of an application for discharge, the court has to proceed with an assumption that the material brought on record by the prosecution are true and evaluate the said material and documents with a view to find out whether the fact emerged therefrom taken at their face value disclose the existence of all the ingredients constituting the alleged offense. At this stage, probative value of the material has to be gone into, and the court is not expected to go deep into the matter and hold that the material would not warrant a conviction. In our opinion, what need to be considered is whether there is a ground for presumption that the offense has been committed and not whether a ground for convicting the accused has been made out. To put it differently, if the court thinks that the accused might have committed the offense on the basis of the material or record on its probative value, it can frame charge. Though for conviction, the court has to come to the conclusion that the accused has committed the offense. The law does not permit a mini trial at this stage. Here, your Supreme Court says the probative value has to be looked into here in this judgment. Now, reference in this connection can be made to the recent.
Probative value means whether he can be relied upon. or not.
Yes, your lordship. Evidentiary value, your lordship. Reference in this connection can be made to recent decision of this court in Swaraj so and so, in which after analyzing various decisions on the point, this court endorsed the following view taken in Onkar Nath Mishra versus so and so. It is true that at the stage of framing of charge, the court is required to evaluate the material and document on records with a view to find out if fact emerged therefrom taken at their face value disclose the existence of all the ingredients constituting the alleged offense. At this stage, the court is not expected to go deep into the probative value of the material on record. What need to be considered is whether there is a ground for presuming that the offense has been committed and not a ground for convicting the accused has been made out. At this stage, even strong suspicion founded on material which lead the court to form presumptive opinion as to the existence of the factual ingredient constituting the offense alleged would justify the framing of charge against the accused in respect of commission of offense. Now, reverting to the decision of this case in Sajjan Kumar and Dilbar Balu Purana relied on by the respondents, we are of the opinion that they do not advance their case. The aforesaid decision considered the provision of section 227 of the code and make it clear that at the stage of discharge, the court cannot make a roving inquiry into the pro and cons of the matter and weigh the evidence as if it was conducting a trial. It is worth mentioning that the conduct contemplated discharge of the accused by the court of the session under 227 is a case trialable by it. Case instituted upon a police report are covered by 239 and cases instituted otherwise than on a police report are dealt with 245. From a reading of the aforesaid section, it is evident that they contain somewhat different provision with regard to the discharge of an accused. Under section 227 of the code, the trial court is required to discharge the accused if it considers that there is no sufficient ground for proceeding against the accused. However, discharge under 239 can be ordered when the magistrate considers the charge against the accused to be groundless. The power of the discharge is exercisable under 245(1) when the magistrate considers for the reason to be recorded that no case against the accused has been made out, which is if unrebutted would warrant his conviction. Section 227 and 239 provides for discharge before the recording of evidence on the basis of the police report. The document sent along with it an examination of the accused after giving an opportunity to the parties to be heard. However, the stage of discharge under section 245 on the other hand is reached only after the evidence referred in 244 has been taken. Thus, there is difference in language employed in this provision, but in our opinion, notwithstanding this difference, and whichever provision may be applicable, the court is required at the stage to see that there is a prima facie case for proceeding against the accused. Reference in connection can be made to the judgment of this court in R.S. Nayak A.R. Antulye. The same read as follows. Notwithstanding this difference in the proposed position, there is no scope for doubt that the stage at which the magistrate is required to consider the question of framing of charge under section 245(1) is preliminary one, and the test of prima facie case has to be applied. In spite of the difference in the language of the three sections, the legal position is that if the trial court is satisfied that the prima facie case is made out, charge has to be framed. In the subsequent decision in S. Salve, this court has summarized the principle while framing of the charge at stage of 227, 228 CRPC, this court has observed and held in para 6 and 7 as under. It is well settled by this court in Ketina of judgment, including so and so, that the judge, while considering the question of framing of charge under section 227 of the code in session case, which is akin to section 239 of CRPC pertaining to warrant case, has the undoubted power to sift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. Where the material placed before the court discloses grave suspicion against the accused, which is not properly explained, the court will be fully justified in framing the charge. By and large, if two views are equally possible, the judge is satisfied that the evidence produced before him, while giving rise to some suspicion but not grave suspicion against the accused, he will fully within his right to discharge the accused. The judge cannot act merely a post office or a mouthpiece of the prosecution, but is to consider the broad probability of the case, the total effect of the statement and the document produced before the court, any basic infirmities appearing in the case, and so. This, however, does not mean that the judge should make a roving inquiry into the pros and cons of the matter and weigh the material as if he has conducting a trial. Here it says, Your Lordship, on mere suspicion also, Your Lordship, the court can discharge. In Sajjan Kumar versus CBI, this court, on consideration of various decisions about the scope of 227 and 228, laid down the following principle. 1. The judge, while considering the question of framing of charge under section 227, has the undoubted power to sift and weigh the evidence for the limited purpose for finding out whether or not a prima facie case against the accused has been made out. This test to determine prima facie case would depend upon each fact, each case, Your Lordship. Where the material placed before the court disclosed grave suspicion against the accused, which was not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. The court cannot act merely a post office or mouthpiece of the prosecution, but is to consider the broad probabilities of the case, the total effect of the evidence, and the document produced before the court, any basic infirmities, etc. However, at this stage, there cannot be a roving inquiry into the pros and cons of the matter and the weigh the evidence as if conducting a mini trial. If on the basis of the material on record, the court could form an opinion that the accused might have committed the offense, it can frame the charge, though for convicting the conclusion is required to be proved beyond reasonable doubt. At this stage, the accused doubt that the accused has committed the offense. At the time of framing of charge, the probability value of the material on record cannot be gone into, but before framing of charge, a court must apply its judicial mind on the material placed on record and must be satisfied that the commission of offense by the accused was possible. At the stage of 227 and 228, the court is required to evaluate the material and document on record with a view to find out if fact emerging therefrom taken at their face value disclose the existence of all ingredients constituting the alleged offense. For this limited purpose, sift the evidence as it cannot be expected even if initial stage to accept all the prosecution stage as gospel truth, even if it is opposed to common sense or broad probability of the case. If two views are possible and one of them give rise to suspicion only, as distinguished from grave suspicion, the trial court will empower to discharge the accused, and at this stage, he is not to see whether the trial will end to conviction or acquittal. In Movin Govinda, this court has occasion to consider how to determine prima facie case while framing the charge under 227, 228. In the same decision, this court observed and held that while considering the prima facie case at the stage of framing of charge of under section 227, there cannot be a roving inquiry into the pro and con of the matter and weigh the evidence as it was conducting a trial. At this stage, the decision of the Istri Achar Birodi Parishad is also required to be referred to. In that aforesaid decision, this court has occasion to consider the scope of inquiry at the stage of deciding the matter under 227 and 228. In the paragraph 11, 12 is observed, Your Lordship. 227, Your Lordship, is speak about the it reflected the ingredient of 227, the procedure what are required to be followed. Para 12. Section 228 requires the judge to frame if he considered that there is ground for presuming that the accused has committed the offense. The interaction of these two sections have already been the subject matter of consideration by this court in State of Bihar versus so and so, while explaining the scope said section. Reading the two provisions together in juxtaposition as they have got to be, it would be clear that the beginning and the initial stage of the trial, the truth, veracity, and effect of the evidence which prosecution or proposes to adduce are be meticulously judged. Are not truth prosecution proposed to adduce are not be meticulously judged, nor in any way to be attached to the probable defense of the accused. It is not obligatory for the judge at the stage of the trial to consider in any detail and weight in sensitive balance whether the fact, if proved, would be incompatible with the innocence of the accused or not. The standard of test and judgment which is to be finally applied before the recording of the finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of decision matter under section 227 or 228 of the court. At the stage of the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in the conviction. A strong suspicion against the accused, if matter remain in the region of suspicion, cannot take place of proof of his guilt at the conclusion of the trial. But at initial stage, if there is a strong suspicion which lead to the court to think that there is a ground to presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. It says, Your Lordship, strong ground, Your Lordship. There must be a strong ground. In Union of India versus Prafulla Kumar Samal, summarize some of the principle. The judge, while considering the decision of framing the charge under section 227 of the code, has to undoubted power to sift and weigh the evidence for limited purpose of finding out whether or not a prima facie case is against has been made out, accused has been made out. Where the material placed before the court disclose grave suspicion against the accused which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. The test to determine a prima facie case would naturally depend on the fact of each case, and it difficult to lay down a rule of universal application. By and large, however, if two views are equally possible, the judge is satisfied that the evidence produced before him, while giving rise to some suspicion, but not grave suspicion against the accused, he will be fully within his right to discharge the accused. This is exercising this jurisdiction under 227 of the code, the judge, which under the present code is a senior and experienced court, cannot act merely as a post office or mouthpiece of the prosecution, but has to consider the broad probabilities of the case, the total effect of the evidence, and the document produced before the court, any basic infirmity appearing in the case, and so on. This, however, does not mean that the judge should make a roving inquiry into pro and cons of the matter, and as if he is conducting a mini trial. The two decisions do not lay down different principles. Prafulla Kumar case has only reiterated that has been stated in Ramesh Singh case. In fact, section 227 itself contains enough guidelines as to scope of inquiry for the purpose of discharging the accused. It provides that the judge shall discharge when consider that there is no sufficient ground for proceeding against the accused. The ground in that context is not a ground for conviction, but a ground for putting the accused on trial. It is in the trial the guilt of the innocence of the accused will be determined, and not the time of framing of charge. The court therefore need to understand an elaborate inquiry in sifting and weight the material, nor is it necessary to delve into various aspects. All the court has to consider whether the evidentiary material on the record is generally accepted would reasonably connect the accused with the crime. No more need to be inquiry into. Apply this law laid down by this court, a process decision, and considering the scope of inquiry at the stage of framing of charge under 227, 228, we are of the opinion that the submission made by this is the observation on that case particularly.
Here, in this case, for discharging the respondent number, private respondents, the trial court had to discard the evidence of the witness, totally discard. Then only he had discharged the
Yes,
private.
he's not relied upon the statement given by
He has not relied upon the statement given on oath.
yes, your lord. That is,
He has given reasons, but at that stage, he had discarded the evidence given on oath. Now the question is whether that could have been done. The judgment which you have read, what I understand says that some inquiry has to be made
yes, your lord.
for coming to the finding that whether there are sufficient grounds or not.
No.
Sufficient grounds for the accused to put to face trial,
Yes,
not for conviction.
yes.
The result may be acquittal or conviction,
Yes.
anything.
Yeah, that may
But
be,
whether sufficient grounds are there so that he may be asked to face trial,
Yes.
or the materials are such that he could not be even asked to face trial. That inquiry is necessary.
Yes, Your Lordship.
But in the instant case, you have the trial court has discarded the evidence of clear evidence on oath by giving reasons. Now, whether that can be done or not, that is the only question.
The question here is,
Some the portion says that even probative value of the,
yes.
some probative value
Has to be taken,
judged.
done, yes.
Otherwise, suppose the IO is not, has not done his job properly, then courts are not bound by whatever IO collects. Some sifting has to be done.
Yes.
But what kind of inquiry or sifting has to be done at that stage?
So now, Your Lordship, the statement, I mean, now the question here is whether the statement which is given on oath under 164, an oath 164 by the John Tapping, whether that will be sufficient, one, to presume that the offense has been committed by this, the accused who has been discharged. That has to be looked into, Your Lordship. And so far as, Your Lordship, here in the present judgment, it also says there cannot be given a exhaustive, Your Lordship, guidelines for that. It has to be depend on the fact and circumstances of each cases. So now here, Your Lordship, the person who has deposed against the accused person, the discharged person, he was considered to be a interested witness, Your Lordship. Now, the question here is, without discarding his evidence, the court has to look into whether it has to be considered to be reliable or not. So, first of all, Your Lordship, first of all, the question here is whether this, from the statement given by the present witness, is sufficient to presume that there ground to presume that the offense has been committed by the discharged accused or not. That is the first aspect. And second is, if he is one of the interested witness, if suppose he's come under the definition of interest witness, Your Lordship, whether without scrutinizing his statement, whether court can proceed or not, Your Lordship. Because in my humble understanding, Your Lordship, if you go into the record, Your Lordship, the FIR, right from the FIR, all the material, Your Lordship, he is the person because of which this incident has actually happened. Purportedly, Your Lordship, I'm not saying that he is because of him he is committed, but as per the record, he is the person who called the deceased person there.
So he was there throughout the
Incident, Your Lordship. And other witnesses were also there, eyewitness, Your Lordship. In fact, his own.
That lady said that she did not notice one of the co-respondent, private respondent. She did not give attention to what one of the private respondent has done. But she noticed another private respondent assaulting the deceased.
Yes, other is.
What exactly, Your Lordship? It says that some persons.
There are many persons were also there.
Because there, in the incident, there were so many persons involved in the incident. The one John Tapping.
After that, we'll continue if necessary.
Yes, Your Lordship. Now, Your Lordship.
Because this is important. If the revision is allowed, they will have to face trial.
Yes.
If it is not allowed, then you have to accept the judgment of the trial court. So it has grave consequences.
Yes, Your Lordship. So, Your Lordship, the statement of other witness may be, at this stage, Your Lordship, we can look into because it's a part of record, Your Lordship. 161 statement.
No, what do you want to say that other witnesses have not implicated?
Yes, Your
That
Lordship.
is-
Not implicated. And secondly, Your Lordship, the statement basing on which, Your Lordship, they've approached this court that there is a sufficient incriminating material against the discharged accused person, basing on which it can be presumed that the offense has been committed by them, Your Lordship. That is their ground, Your Lordship. That the 164 statement on oath which has been given, that will be sufficient that ought to have been prosecuted along with the other accused.
How many accused were there?
Total one is under trial, Your Lordship.
Trial.
Yes.
Three
Total
accused.
three, including both the discharge.
Three accused and one deceased,
Yes.
one injured witness, and
Yes.
that lady.
More, Your Lord. Total 14,
14 people were there,
15 witnesses are there.
15 witnesses at the place.
Yes.
Some of them have seen some of the accused. One has been seen by all. The person who is facing trial
Yes, Your Lordship.
against him, all of them have deposed.
The person who is under trial, Your Lordship.
Trial.
That person, Your Lordship, he has not deposed that they all were they all have assaulted the
No.
deceased.
What I'm saying that in a case there may be 14 witnesses.
Yes, Your Lordship.
All 14 need not to depose that all three have. I have
Yes,
seen-
exactly, Your Lordship. It's
Even
the
if-
quality, Your Lordship. Yes, Your Lordship.
Even suppose one of the witnesses.
Yes, yes, Your
I've
Lordship.
seen other two also assaulting. And whether he can be relied upon or not. But that examination
Yes, that is there.
stage is at a later stage.
Yes, section 134, yes, the
That is
quality.
the submission of the council for prosecution.
Yes, it's the quality, Your Lordship. So now the question here, only the issue here is, Your Lordship, the person has been considered an injured witness, Your Lordship, as of now, but as per the order of the, seeing the, Your Lordship, the finding of the learned trial court, Your Lordship, the statement which has been given by Mr. Tapping, Your Lordship, it has to, before going into that, before make any presumption, Your Lordship, court has to see the other material as well, Your Lordship. Because in my humble understanding, Your Lordship, he is one of the interest witness, Your Lordship.
No, that finding, when can you arrive at that finding? When can you sift that whether he is interested witness or injured witness? This exercise has to be done, that is my query, at a pre-trial stage or at this stage of trial. Now we are concerned with pre-trial stage when charges are either to be framed or discharged.
Yes, Your Lordship.
Before recording the statement of that witness or
Yes.
not during trial. In trial, the said witness could have deposed where he could have been questioned, cross-examined. But that stage, and thereafter, after cross-examination, the court would have sifted the quality of the evidence, whether to rely on or not.
Yes, Your Lordship.
Now, at the stage of framing of charges, whatever has been collected by the IO, only that is before the court. Now, at that stage, whether court can label a witness to be interested witness, label a witness to be unreliable witness. That is my query. If answer is no, revision is allowed. If answer is yes, revision is dismissed.
My lord, there are 60 of my judgment, it's clear cut.
No. Let him go.
Sorry.
Now, Your Lordship, regarding whether he was interested witness or not, Your Lordship, no doubt it has to be.
You have pointed out one more thing. Suppose petition is allowed,
Yes, Your Lordship.
then there will be complications in trial now. Because the trial is at
Yeah,
DW stage.
The defense is
Then against them, again witnesses.
re-examine,
Re-examine.
re-examine, Your Lordship. And Your Lordship, the witnesses which were examined, they were there in the place of occurrence, Your Lordship. So whatever has been deposed before the session court during the trial, they have deposed whatever they have seen and whatever has happened at that point of time, Your Lordship.
So you have to call again two witnesses, this injured witness and the lady witness, who have stated during investigation.
Yes, Your Lordship. They have to be re-examined, Your Lordship.
Others need not to be re-examined.
Your Lordship, lady witnesses has not stated that she has seen both of them
One
assaulting.
of them she has.
I don't.
Shan, she has seen. Shan has joined the fight.
Yami, Komi, Your Lordship, well,
Yami,
let's read out the statement of this Yami Komi, Your Lordship. Yeah. Wait a minute. What is it? Hey, yes, I mean, yeah.
no, Yami at page number 50, she has said that immediately rushed to spot. So I went to the ground floor and saw Tanua and John fighting with each other.
Yami Komi Ngogen, page 49. I then saw John talking, last para, Your Lordship.
No, before that, earlier paragraph,
Okay.
in between, after they left.
In the meantime, when I was inside kitchen, I had some argument, so I came out of John and Dichen in the house once again, and I saw John and Tanu Chije were arguing regarding his title. So I told them not to fight in my house. I did not see any physical fight at that time. It was a verbal argument, and they also sobbing each other on their arms. Then John Dichen, two of the Dichen girlfriend, and one more boy whom I did not recognize left the house. Tanu also followed them. When they left, San was busy.
Shan is one of the private respondents.
Number 2.
San was busy eating food in kitchen. After they left, I heard noise outside the house. After San finished his food, he also immediately rushed to the spot. So I went to the ground floor and saw Tanu and John fighting. Tanu and John, Your Lordship.
Okay, then read again.
With each other outside the house gate. The area is visible due to lighting of the building. I saw that even San joined the fight with the other boy who had come with John. Other, Your Lordship, there are many boys, Your Lordship. Many boys were there. At that time, your deceased was not the only person who was there, Your Lordship. There are many boys. And I did not see Komi fighting with any of them. But I did not pay attention to where he was at that time. The rest of them were all engaged in physical fighting with each other. I, along with Dichen and two other girls and Pema, were standing inside inside the house gate. I saw John talking to his phone and he was calling somebody, Your Lordship, asking him to come and help. Here, Your Lordship, then John called the deceased. I heard him say, "Humko 3 ladka milke maar raha hai." After that, the fight settled for some time, but at that time, another boy came to the spot, say, "John Taping ko kon." This is the deceased, Your Lordship, who appeared. This is the time when deceased appeared. And the girl were trying to stop him, saying, "Mat jao." But the boy didn't listen and he tried to kick Tanu, who had his back turned toward him, but Tanu turned around and pinned him to the ground and gave him punches on his face. Here, Your Lordship, the deceased name, the other accused name has been revealed. Then John and his friend took the boy to the hospital, and even, Your Lord, he has not stated the name of the discharge accused. At that time, the deceased person was not in the picture, Your Lordship. Initially, they were fighting, but the John, he called the deceased person, and the deceased person rushed to the place, and then he said, "Kon tapin ko maar raha hai." Your Lordship. It was the statement of the deceased. She has not identified, Your Lordship.
No, she states that John joined the fight with the other boy who came. Shan joined with the fight.
Your Lordship, I then saw
I
John talking on his phone and calling somebody, asking on phone, calling somebody, Your Lordship, him to come and help. I heard him saying, "Humko 3 ladka maar raha hai." The John has been assaulted by 3 of the boys. After that, the fight settled for some time. That means the fight between the John and the 3 boys had been settled. But at that time, another boy came. This is the deceased person, Your Lordship. Another boy came to the spot saying, "John Taping ko kon mara hai." And the girl were trying to stop him, saying, "Mat jao." But the boy didn't listen and he tried to kick Tanu, who had his back turned toward him, but Tanu turned around, pinned him in the ground and gave him punches. It is the Tanu, according to the 161, he said, who assaulted that person, who all of a sudden came because the call has been made by the John. Prior to the any assault made to the deceased, there was a fighting between the John and the other boys, your lordship. The deceased person come later.
No, but this much of going into the evidence out of so many accused persons who actually hit, though Shan was involved in a fight, he was not fighting with the deceased.
Yes, he was not fighting with it.
These evaluation of evidence, can it be done at this stage of,
Well, robbing inquiry, no doubt cannot be done, but your
at this
lordship,
stage of framing of charge,
Wh-
when
whether,
one of the witness has categorically stated that the private respondent also attacked?
and your lordship, here your lordship will find, here the John Tapping, he called the deceased person when at the time when he has a fighting with the other person. So considering that except because all of a sudden that person come because that John call him up and there was an scuffle between the Tanu and that deceased person. Ultimately your lordship, the deceased person unfortunately he died, your lordship. There is a sufficient material against the Tanu, no doubt, your lordship, but not against these two accused person who has been discharged.
Anything else?
Your lordship, since interest witness
What
can
is
be.
your submission? You make your submissions tomorrow. We'll fix it tomorrow.
Your lordship, tomorrow I have some personal.
No, your part is over. You will not reply. I'll
Okay.
record your submission.
Okay, I deeply oblige, your lordship.
Or do you have anything to say?
Your lordship, I have some judgment, your lordship, few judgments on interested witness as well, your lordship. What expectations we can
No,
take.
at the stage of framing of charges,
But
this aspect can be gone into.
But your lordship, the judgment which I relied, there the Supreme Court clearly says the court has to look into the material and has to find out the.
For limited purpose.
Yes, your lordship, for limited purpose. So at least court has to know what incident has exactly happened on that point of time. At least that much court should know, your lordship, while evaluating, because court has to apply its judicious mind, your lordship. It says so. So at least court has to know what incident exactly has happened at that point of time, right from the beginning and right from the end, and who were involved involved at that point of time. That has to be looked into, your lordship. I'm not saying which evidence is right, which is wrong, but
Okay.
it has to be seen.
Okay, then why the evidence of? Why the evidence of, what is the name of the injured witness?
John Tapping, your lordship.
Why the evidence of John should be discarded?
Your lordship, the statement, your lordship, that is the reason what I trying to, your lordship, projecting, your lordship. The fact has to be clear, your lordship. What is his exactly role? Why court has considered him? No doubt that aspect has to be considered at the trial stage, but why before relying on the statement of this John Tapping, why court has discarded his statement? Whether if even if take that statement of this
If he
John
has-
Tapping.
If he has been labeled as interested witness, then his evidence as against the person who is facing trial, that means Tanu. His evidence will not be relied.
Totally now it's wiped out.
That you have already been regarded as interested witness, even against the person who is facing
Yes.
trial,
Yes.
the defense will take that plea. That court has already came to a finding that he is interested witness. So his witness should not be relied
My
upon.
lord is rightly said.
And your lordship, other statement of the other witnesses is also there, your lordship.
No, other witnesses are there, but you are discarding
Oh, yes, yes.
evidence of a crime.
But I'm not saying on toto, your lordship. It has to be scrutinized, your lordship. Along with scrutinize means what, your lordship? It has to be seen with read with the other witness statement of the other witnesses. It cannot be relied solely with. It can be relied if corroboration is there. Then court can definitely go into that, your lordship.
Then you have to place them. This is important.
Interested witness. Yes.
All judgments which on
And your lordship, the other judgment is regarding your lordship 319, because your lordship, the trial has been proceeded to some extent, your lordship. Now, if it is, if now your lordship, there is a sufficient evidence, because your lordship, the fact and circumstances of this case is like that, your lordship. All the person were there, present, who are the
now
prosecution
this-
witness.
This has been put to challenge under what provision?
It's all provision of the CRPC 397.
397.
Yes, your lord.
What are the limitations under 397?
My lord, so the propriety, legality, perversity. Whether the laws have been, my lord, properly followed or not. My case is, my lord, that the first perversity is there. Because finding conclusion of the learned trial court is that.
Then you have to answer, reply to the PP's submission
I will
also,
reply. I
that
will reply.
he's one of the stand is that once a way is open under 319, but none of the witness have stated during trial anything
Yes.
against
Yes.
these two.
Among the abuse of
Then-
process.
You cannot invoke even 397 now at this stage.
Yes,
That is your
yes, your
submission.
lordship.
You have to reply not now, not
Okay.
today.
Your lordship, I will rely only two judgment, first on interested witness and second on 319. Why? Because your lordship, even the accused who has been discharged, they can be aired as an accused by invoking 319 by the concerned court, your lordship. If there is a sufficient evidence, your lordship, causant one, if unrefuted, lead to conviction, your lordship. Your lordship, first I will rely on rely a decision of 2013, volume 15, SCC 298, your lordship.
No, whether he has been already examined.
Yes, your
John-
lordship.
John,
John,
Don't
examine your lordship. Now it's for defense witness only, your lordship.
in John's evidence, he has not stated
Stated, my lord.
Stated your lordship.
during
Yes,
trial,
yes,
during,
Yes, he has stated, but his statement is inconsistency. So because of that reason, that his statement cannot be relied upon. So he stated 164 in,
Oh,
something
contradiction.
else, in, the position in something else. So there is a
no,
inconsistency.
before the court, during trial,
Yes,
whether he has stated that these two have also assaulted.
yes,
He has stated.
Yes, yes.
Then why 319 was not invoked? Why?
That is the trial court rule.
They have the remedy, your lordship. If there is a material, they can invoke 319, your lordship. Because trial court is not denuded of power at this stage also.
Tomorrow is, you have difficulty, no?
Yes, your lordship.
Then day after tomorrow?
Yes, your day after
When?
tomorrow.
Because we'll continue with this. We have already. You will show a judgment which shows that discharge accused. We'll continue with this on day after tomorrow.
And even in your lordship, the 313, that's what applies the code. 313, the accused who is under trial, he has admitted that he is the person who has assaulted he is the sole person who assaulted the deceased, your lordship.
But 313, he will.
Is a corroborative value, your
He
lordship.
will answer only to those questions which are put to him.
Yes, inculpating him in the circumstances.
Yes. Because the incriminating evidence against these two might not have put place before.
But the question here is, your lordship, the question here is the fact and circumstances of the case, your lordship. The witnesses, they all were there, your lordship. And if they divorce, they cannot divorce, your lordship, and pick and choose basis, your lordship. They have to divorce everything, your lordship. Anything, they have, in fact, the this defense, no, not defense, prosecution side, your lordship, the prosecution side, they can call it out, your lordship, in chief as well as in cross examination. If nothing is there, then your lordship, even if it is, in my humble understanding, if it is interfere, if it is sent for retrial, your lordship, because the other witnesses has to be re-examined, your lordship, it will amounting to abuse of process when 319 is already there, your lordship. 319 power jurisdiction of the trial court, your lordship.
No, why 319 was not invoked when John has stated in his evidence during trial on oath again?
The learned part, as on that, your lordship, since they have, the court has not invoked and even they have not approached the court, meaning
No,
thereby,
it is the power of the court only.
yes, your lordship. Meaning thereby, your lordship, it can be presumed that there is, that evidence is
No,
not
they
more
have-
than prima facie to,
They have not invoked because they have already challenged the discharge order before this court. Therefore, they have not invoked.
that liberty can be always be given, your lordship. If that is there, then liberty can be always be given, that if there is a sufficient material, cogent one, which is more than prima facie, if unrefuted lead to conviction, then court can exercise the power, your lordship. At this stage, your lordship, regarding the development of this stage.
My
of the-
lord, this, I am here, my lord, challenging basically legality, propriety of the order. My lord, because
Okay,
yet-
on the next day, whenever we fix it now, shortly, 1 or 2 or 3 days, you have to make submissions regarding the scope of this court to interfere in such order in exercise of its revisional jurisdiction when the trial has fairly progressed and it is at the almost nearing the end. What court should do under such circumstances? On that also you may have to make submission. We are putting a halt on the hearing today.
Yes.
We will continue with, choose a date.
Any date, not tomorrow, but any other date, your lordship. Convenient.
Day after tomorrow,
Okay, your lord.
After tomorrow, my lord, I'll be out of station, my lord.
you
Can we
suggest,
28th, my lord.
because it should not be at the end,
Yes, on Thursday.
because I am also here for limited time.
Yes, yes, yes.
28th is okay.
My lord, 20.
28 as the first, 28 is the hearing date.
Next item.
As part heard matter, we'll take it up as first hearing item
Okay, your lord.
after regular motion and all that.
Okay.
Heard Mr. R. Sona, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor, as well as Mr.
K-O-C,
K.
K-O-C,
K. Posi, P-O-S-H-I.
P-O-S-I,
K. Posi, learned counsel for the private respondent number
2 and 3.
2 and 3. Hearing remained inconclusive. Please this matter again on 28 8 as part heard matter.
My lord, this next item number 29, that that matter may also be my lord, taken up on 28. That's a very simple issue, I think.
Yeah, very simple, yes.
Only the issue in this, my lord,
Compliance of the,
compliance of 133,
133.
that preliminary notice and that inquiry has not been done. Directly, order has been passed in violation of.
When should we fix it?
On the
Same
same day.
day.
my lord.
Item number 29.
Yes.
We heard Mr. R. Sonal, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. Due to paucity of time, this matter could not be heard today. On the request of learned counsel for both the sides, let this matter be listed again on 28/8/2024. This you have to keep it in a separate file. Keep a separate file. What is another matter?
W.
oblige, your lordship.
What is 32? Today we don't have any time. When should we fix? We, oh, 27 dB is there. 27/9. Yes, okay, Mr. Tado. Heard Mr. C. Foucault, learned counsel for the petitioner. Also heard Mr. G. Tado, learned additional public prosecutor. Due to paucity of time, this matter could not be heard today. On request of learned counsel for the petitioner, let this matter be listed again on 27th of September 2024.
Obliged.